Okay, so good morning, everyone. Slight delayed start this morning, but thanks for everyone's patience for getting us up and running, both with Brodie's and the webcast. So it's 10:16. I'd like to open this hearing session, which concerns the appeal by Energy Contour UK Limited against the decision by Dumfries and Galloway Council to refuse an application for planning permission for a wind farm at Little Hartfell, Corrie Common, near Lockerbie, comprising 9 turbines and associated infrastructure. I'm Judy Craggs, and I'm a reporter with the Planning and Environmental Appeals Division of the Scottish Government, and I've been appointed to consider this appeal. As the case has been recalled by Scottish ministers for their determination, I will submit a report to Scottish ministers with my findings and recommendations, and it will be for Scottish ministers to determine the appeal. This is a virtual session and is being broadcast live. It will be stored as part of the DPA website archives and will be capable of repeated viewing. By participating today, you're consenting to being filmed. You're also consenting to the use and storage of these images and sound recordings, and if any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making these records available to the public. Further detail on DPA privacy policy can be found on the DPA website. So first of all, thanks to my IT colleagues for arranging today's meeting, and to Rebecca for webcasting today. She's in the background, but hopefully there's no more technical issues, but if there are any technical issues, I'm sure she'll step in and sort us all out. So all of those I think I'm expecting to participate today have joined, so thank you. For the benefit of the live broadcast, can the lead participant for both parties introduce yourselves and those participating on your behalf? So if I start with the appellant first, Mr. Collar, can you introduce your team, please?
Good morning, Madam. Neil Collar, solicitor at Brodie's. I'll maybe get the team to introduce themselves, because that way you can check the sound levels and make sure that you're able to hear them okay. So if we go that way and go around.
Able to hear me? Hi, I'm Eliza from Energy Contour.
Morning, everyone. Duncan Taylor from Energy Contour.
Morning, Michael Briggs from Energy Contour.
Good morning, Mark Paul Buckingham from Zai Engineering.
Great, thank you. I can hear you all perfectly well, so thank you for that. And for the Ministry of Defence, Mr. Milne.
Good morning, ma'am. My name is Douglas Milne. I'm a partner at Morton Fraser Roberts, representing the Ministry of Defence today. Just going round the witnesses for the MOD. Joining remotely is Mr. Stephen Laws. Mr. Laws is the national authority for the purposes of the Comprehensive Nuclear Test Ban Treaty. And in the room here with me today, although we're all on separate cameras, is Mr. James Houghton of the Defence Infrastructure Organisation, Dr. David Bowers of the Atomic Weapons Establishment, Black Nest, AWE Black Nest, Mr. Fraser Littlejohn of Montague Evans. Those are the witnesses for the MOD.
Jen, thank you for that. I can see everyone on my screen, so that's great, thank you. So as set out in the note of the pre-examination meeting, there are going to be 2 hearing sessions. The format of each is a structured discussion between the parties, chaired and guided by me, based on the agenda that was issued last week. Relevant questions of the other party can be asked through me, but hopefully we'll get to an actual flow, an actual discussion as we go through the morning. The purpose of the session is to allow those taking part to put forward their views to support their position, and at the same time to allow me to obtain the information necessary for me to report to ministers and make my recommendations. And please remember that even though it's webcast and I can go back and look at the recording, I do like to take notes as I'm going through, and I will be thinking as I hear the responses to the questions. So please speak slowly, one at a time, so I can take notes. I may ask you to repeat something. Also, I'll probably ask follow-up questions, so that can be how the discussion goes. There will be no opening or closing remarks or submissions from either party today. We agreed at the pre-examination meeting that the parties would submit closing submissions in writing after the hearing session, and we'll discuss the timescales for that once we conclude the hearing sessions themselves. Documents will not be shown on the screen, so hopefully you've all got either hard copies or electronic copies you can look at as we go through the hearing today. If you're referring to a document, can you please give me the document reference just so I can again put it in my notes? It just makes writing up the report a whole lot easier. Phones and other devices must not be audible during the session, albeit I appreciate that for those who are not in the same room, you may want to contact one another, which is absolutely fine. Just make sure it's not audible to the rest of the hearing. If you do need a short adjournment for those who are not in the same room to discuss any point, then please let me know and we can adjourn for 5-10 minutes if that helps. We will have a short break at a convenient time during the morning and again in the afternoon, and we'll break for lunch around 12:30, 1 o'clock at a convenient point. If we don't finish today, we will reconvene tomorrow morning and we can agree at what time we will do that when we get close to the end of the day to see how far we've got on today. So before we move on to the actual substantive part and look at the agenda, are there any procedural matters that either party wants to raise? So, Mr. Collar, any procedural matters?
No thanks, Madam.
Mr. Milne?
No, thank you. Nothing from me.
Okay, great. So the first hearing session concerns the impact of the proposal on the Estill Muir seismic array. And we've got the agenda which was circulated last week. And I appreciate it has got a lot of questions on it, but it was more going through my thinking what I wanted to know to write up my report, my recommendations. There may be some duplication, and it may be as we go through the discussion this morning, some questions we don't need to go into because they've been covered in other questions. There will be follow-up. Some questions may be answered very quickly, very short answers. Some answers may have more discussion. That's absolutely fine. I will keep the discussion moving, and when I feel I've got enough information that I need, then we'll move on. So turning to the first question, and probably the first question, item 1 and 1A, probably can be taken together. And it was really this point about whether the plan permission is expired or not. So really, I'm asking, if I take the view that's not expired, or ministers take the view it's not expired, is it reasonable to treat the appeal proposal as a replacement scheme on the basis that if the appeal is allowed, both schemes could not be constructed? And then I was looking at the law that had been submitted by the appellant on this, and the second part of the question is, when considering when plan permission for the consented development has or hasn't expired, is the key issue that may need to be given to, and it's the phrase, at the end of a specified period, which is in section 41(3) of the 1997 Act. And I wondered if a specified period could be determined by reference to condition 2. So I'll start with the appellant on this, and I think your view is that the proposal is a replacement.
That's correct, Madam. And a useful reference would be in our appeal statement, which we've numbered APP-1-2, and it's in paragraph 5-3, which just explains that the turbine positions are not being altered. As a expansion on that point, as it were, the conditions do involve a micrositing allowance, but Mr. Briggs could maybe explain to you briefly that in terms of the warranty position, let alone use of wind resource and whatnot, it just would not be possible in practice to have a situation where the micrositing allowance could be used so that both schemes could be built out, if you see what I mean. I'm not explaining it terribly well, but I think you understand the point I'm making. You're smiling, so thank you. Mr. Briggs, if you want to touch on that warranty position, and then I can maybe pick up on the point about the interpretation of the statutory provisions.
Sure. So each scheme will have its own micrositing allowance of 100 metres. So theoretically, on paper, you could move each turbine 100 metres away from its starting position and give yourself a maximum of 200 metres distance between the two turbines. But that's just not enough, really, practically, to build turbines in such close proximity. The minimum requirement we need to achieve to obtain a warranty from the turbine manufacturers to get around 3 times the rotor diameter separation between the two turbines, which in this case would be about 400 metres as a minimum. And where we're not able to achieve 3 rotor diameter separation, the turbine manufacturer just simply won't provide us a warranty, and probably won't even provide us with the turbines in the first place, and we're never going to be able to finance and construct the project on that basis. So it really is a replacement scheme, and it's a case of we'd only be able to build one of the stations out.
Just to add one point to that as well, ma'am, if I may, and to address a point which is pondered in MOD's hearing statement at 3.22, that's electronic page 9, where they ponder as well whether we might implement a partial implementation of both schemes. And it's just to make that point again that no, the intention is to construct only the proposed development. And on that point, if it was felt necessary, the appellant would be happy to propose wording for a condition to offer added protection. And we have experience of this. We've recently gained planning permission at Cornharrow, Dumfries and Galloway, where which was also a replacement scheme, where the reporter attached a condition under similar circumstances. So again, if it was necessary for that extra protection, notwithstanding the points so for Mr. Briggs have just made, would be happy to provide those wording.
Okay, thank you for that. Sorry, I was going to take to paragraph 3.22 of the MOD hearing statement, so you've covered that point for me. Just before we go into the law, Mr. Collar, Mr. Mullin, do you have anything your team want to add to this? Because really you felt it was a point for the appellant to explain whether it was a replacement or an alternative. So is there anything you want to add? Would a condition I suppose give the MOD a bit more comfort on the point?
Thank you, ma'am. Yes, it would be helpful to see a proposed condition, and consideration could be given to that from the MOD's perspective. But yes, ma'am, as the MOD has said in its hearing statement, this question does seem to us primarily to be for the appellant to answer, but I will ask those in the room, principally Mr. Littlejohn from a planning perspective, but also Mr. Houghton from BIO's perspective, whether they have anything to add.
Thanks, Mr. Milne. Yeah, I think from my perspective, just sort of keen to make the point that within the appellant's hearing statement at 4.5, there's reference to the circumstances of a replacement scheme being similar to a house builder seeking a new permission. And it was just to make the point that I think we need to, from the MOD's perspective, draw a bit of a distinction in terms of the nature of what's being proposed at Little Hartfell. I'd suggest that using that reference at 4.5 probably seeks to suggest less of an impact from MOD's perspective than there may be in the example that's given.
Mr. Houghton, do you have anything?
Nothing further to offer on that one. No.
Okay, thank you. I'll come back to you now, Mr. Collar, on the legal point about whether the permission has expired.
Thank you, Madam. In your 1A, you're asking, is the key issue the meaning to be given to the phrase at the end of a specified period? The answer is yes. And your further question, can a specified period be determined with reference to condition 2 of the planning permission? And again, the answer is yes, in combination with condition 3, because condition 2 sets out that the planning permission endures for a period of 25 years from the date of final commissioning, and provides for written confirmation of that date, the date of first commissioning, to be given to the planning authority. And then condition 3 requires the development to cease generation not later than the date following 25 years from the date of final commissioning. So the two conditions in combination provide that clarity on the timescales.
Thank you, Mr. Mullin. I guess I'd like to understand why the MOD think it's not a permission granted for a limited period.
Thank you, ma'am. I appreciate this well, hopefully this is clear from the MOD's hearing statement that the MOD's case is not held in any way on this argument being successful, but it does seem to be potentially a relevant point from the MOD's perspective. So with that introductory remark, that the MOD's position is a straightforward one. Yes, the MOD does agree that this hangs on the meaning to be given at the end of a specified period. Looking at conditions 2 and 3 of the consented development planning permission, the point is that the removal and discontinuation dates are unknown, because those dates depend on, as Mr. Collar has just explained, the date of final commissioning. And at this point in time, the date of final commissioning cannot be determined. That is, as a matter of fact, an unknown. Taking the appellant's argument means that until the date of final commissioning is known, is triggered, and can be used as a calculation point, this planning permission, the consented development planning permission, will last in perpetuity. And on that basis, it cannot be that this planning permission has been granted for a limited period. For a planning permission to be granted for a limited period would be in the more familiar circumstances of a condition saying that the use permitted by this consent must end within a period of 10 years from the date of granting.
Mr. Collar?
Thank you, Madam. I think this takes us back to the phrase that you had picked out in your question, at the end of a specified period. It doesn't say a specified date, and my submission would be that the conditions set out a specified period. The fact, as Mr. Milne has set out, that we currently don't know when that would be is irrelevant, because there will come a point at which we will know. So in my view, this is a permission that fits within that phrase, at the end of a specified period.
Can I just?
Yeah, no, carry on, yes.
If I just add, just by way of factual updates, see, we wrote to the council on the 28th of Feb to set out our understanding of the legal position, as whether the permission is still live or not. And that email set out in appellant document 008.013. And I suppose one of the main purposes of that email was to highlight to the council that the MOD is taking a position that the consented development has lapsed, but as we understand it, the council doesn't agree with that position. So we were inviting the council to respond to us if they did disagree. They haven't done that. They've not been in touch with us, with the MOD or with the DPA, to say that, in their opinion, the consent has lapsed, and they're continuing to act as if the consent hasn't lapsed. They've accepted and validated and processed our application to discharge condition 32 of the consented development, and they've been consulting with the MOD on that condition discharge following the foreside refusal as well. So at the end of the day, it's for the council to decide whether the permission is live or not. They're the ultimate arbiters of it, and they're responsible for enforcement. If we decide to turn up with some construction machinery to start building the wind farm, it's the council who will come out, and they're very much behaving as though the permission is live and hasn't expired. Yeah, that's the kind of factual update, really.
I think just as well to focus in on the appendix, the 813. If we look at section 41, of the Act as it's quoted in the email to Dumfries and Galloway Council. It provides verbatim the definition as it's given in section 41, subsection 1B, which defines what planning permission for a limited period is, if it should qualify. And we've set out as well in the same email why Little Hartfell is planning permission for a substantive condition. So if it qualifies, I'll have to quote it. It's for requiring the removal of any buildings or works associated, authorised by the permission, or the discontinuance of any use of land so authorised at the end of a specified period, and the carrying out of any works required for the reinstatement of land at the end of that period. So there's no requirement there to say when it should start and the period within which the land should be reinstated. It is simply if there's a specified period after that, the land must be reinstated. And the specified period, as we've said, is prescribed in condition 3, that's the 25 years.
And condition 3 also makes it clear that the site has to be decommissioned and restored at the end of that period.
Exactly. So it's interesting. It was a question we're going to ask on MOD why they felt that this is not planning condition for a limited period, and we pondered whether it was because that that part of section 41, of section 58, has since been removed. So from October 22. That's been taken out, so that any permission granted now is for 3 years, and there's no exception for planning permissions granted for a limited period. Obviously, Little Hartfell was granted prior to that, and so that's the appropriate legislative context for that permission.
Okay, thank you for that. Mr. Milne, do you have any response to that at all?
Ma'am, you have the MOD's position, which can be and hopefully has been simply put. But really the only comment, I think it was Mr. Briggs who was speaking, obviously I'm trying to get used to the voices, made a comment about the council being the final arbiter. Now, to respond to that, this is a matter of law, so the council would not be the final arbiter. Ultimately, that would be for a court to determine. If the council is acting inconsistently with the law, well, that would be the position. It doesn't make a consent which has expired cease to have expired.
Okay, Mr. Cole, unless you've got any final comments, I'm happy to move on from question 1 and 1A to question 2.
Nothing further, Madam. Thanks.
Okay, thank you. We'll move on to question 2. And this is in relation to the offside decision and when that should be treated as being final. Now, I know we're in a funny situation in that the period for JR, I think, expires on Thursday. We will address that, and I will actually address that in the closing submissions. But just for the purposes of today, also by the time I make a recommendation to Scottish ministers, I will know if it's been challenged or not. And I just want the parties to explain that if it is challenged, how should I treat the decision and the noise budget allocated to that wind farm? So again, I'll start with the appellant and then go on to the MOD.
Thank you, Madam. In the appellant's hearing statement at paragraph 417, I've referred you to the ARCID decision from the Court of Session, which is APP-170. And just noting in passing that the Fosside decision, if it is challenged, it would not be a statutory appeal. It would be what I refer to as a common law judicial review. I forget now, I think it used to be Order 53 procedure. And the ARCID decision, likewise, is not a statutory appeal. It's a common law judicial review. The ARCID decision is sort of foursquare, if you like, with the circumstances with Fosside. The circumstances of the ARCID decision don't matter. It's a general principle. For your notes, it's at paragraph 55 where the Court of Session set out the principle. And that is, as a matter of law, a decision which is under challenged is treated as valid unless and until quashed. So in my submission, as a matter of law, even if there is a petition for judicial review submitted in the course of this week challenging the Minister's decision on Fosside, the legal situation is that decision is treated as valid. In other words, the refusal stands even though it is under challenge. And just as a further point, although as I've set out, Fosside would not use the statutory appeal procedure, it's useful just to note in passing that the statutory appeal procedure, for instance, under the Planning Act, has provision for interim suspension be granted by the court of the decision or order or whatever it is that's under challenge. Now, clearly, if the submission of the challenge per se suspended the decision or the order or whatever, there would be no need for an order of interim suspension. So the existence of that power, again, supports the legal principle that a decision is treated as valid unless and until it's quashed. And then the other point that I made, I can't now remember, sorry, if it's in, I think it is in the hearing statement, it is just the pragmatic point that it might be thought, oh, there's a risk of double counting in terms of the budget, that if in some way, because the Fosside decision is still treated as valid, and for the sake of argument, another wind farm is granted, then continuing the hypothesis, if the court did quash the Fosside decision and the Fosside application revived, could that end up as a double hit, as it were, on the budget? But again, as a matter of law, that is already taken account of, because a revived Fosside application would fall to be determined on the basis of the new circumstances, not the old circumstances. So if, following my hypothesis, another wind farm had been granted that took budget, a revived Fosside application would have to take account of that. So as a result, there's no risk of double counting, which again supports the general legal principle that the Fosside decision is treated as valid, and unless and until the court hearing the petition decided that it was invalid and quashed it.
Thank you for that, Mr. Millen. I'd like to respond to that and maybe set a legal basis for the MOD's position on this.
Thank you, ma'am. Again, as an introductory remark, the MOD understands from a telephone call received from Community Wind Power yesterday morning, Community Wind Power, of course, being the applicant for the Fosside wind farm development, that they are not intending to seek judicial review. Now, of course, the MOD's approach is to wait until the period for lodging judicial review has expired, and of course takes account of the fact that it can take a week to 7 days for such a petition to be served before it would remove an application from its list, and that is how it will proceed. But that's the phone call which was received yesterday, so I think it's helpful to note that for the purposes of this discussion. In terms of the appellant's reference to the ARCID case, and I don't take any issue with what ARCID says, of course, but the MOD's position is that a reference to that case is really to miss the point. The MOD's concern here is to safeguard the array, and in doing so, it seeks to adopt a predictable approach, and it seeks to apply that approach consistently, and it seeks to avoid uncertainty. We will speak later, no doubt, about the MOD's intention to consult on a published policy following the Energy Contour Little Hartfell judicial review a couple of years ago. But the important point from the MOD's perspective is that it has consistently taken the view over many years and has adopted this approach that an application is removed from its list following final determination and the exhaustion of any appeal. So while it may, as a matter of law, be the case that a decision which has been taken remains valid until it is quashed or that there is an order for interim suspension made by the court, the MOD's approach in seeking to act consistently and predictably and in a way to avoid uncertainty is not to remove that application until it reaches the final point, as I have explained. If the MOD was to take the appellant's approach here, which is an innovation on what has happened in the past, this has been raised for the first time in this appeal. This is not something which has been discussed with industry and would come as a surprise to third parties if that's how things were to be dealt with. A theme of what the MOD is going to be saying throughout this hearing session is that ad hoc decision making to adopt a new approach in the context of a particular application leads to uncertainty, and uncertainty is what undermines the safeguarding of the array. In my usual way, I think it might be helpful to ask if Mr. Littlejohn or Mr. Watton have anything to add to that, in particular on my theme of uncertainty.
Yeah, happy to just respond to that point, Mr. Nolan. I think from my perspective, we're working with the MOD at the moment around about suitable responses to the Scottish Government discussions and also requirements around about the consultation. And in a lot of respects, it does sort of go back to the point we've just been discussing, I think, in terms of the specified period of any consents. One of the things that we're looking to discuss with the MOD is just the surety around about decision-making process and having certainty as to when developments ultimately come forward to be able to suitably review the baseline and to undertake an audit in order to proceed from decisions that are being made to the next again steps in terms of protocols for planning applications to be considered as well. So there's a lot of discussions going on at the moment around about the nature by which sort of planning applications for renewable development are considered as part of the process ultimately in going forward. And there's as you might expect, a lot of sensitivity around about the nature and detail of planning applications that are being determined that do have the potential to ultimately impact on the consultation zone and the array itself. So yeah, I think that is another dimension, and it's a sort of multi-layered approach to what the MOD are having to consider when they're assessing the impact of any of the developments.
I'd echo both those comments. Say uncertainty is the last thing we need to safeguard the array. We need to avoid it at all, on all occasions. Yes, certainty is key for us. Thank you.
So, Mr. Mull, just kind of summarising what I think was said there is that I don't think you're disputing the law that Mr. Collar's kind of outlined in that case, what that case says, but you're saying that the MOD take a different approach. The approach you're taking is to ensure certainty, consistency, and to ensure their array is protected. So their policy and their procedure is slightly different because of the duties on the MOD to protect the array. Is that a fair summary?
That's a fair summary. And rather than immediately removing Foresight on the 22nd of December, when Scottish ministers took their decision to refuse that application, with the possibility of putting it back at the end of the list, if and when the Court of Session had granted the judicial review quashing that decision, and then the application had gone back, presumably to a reporter, to consider a fresh in light of the court's opinion and make further recommendations to ministers. The MOD is looking for something much more straightforward, and its current approach falls into that. The intention of the MOD to consult following the judicial review a couple of years ago, a draft consultation document has now been prepared and is being considered internally within government and discussed with the Scottish Government with a view to that policy aligning with the consultation which Scottish ministers are intending to undertake shortly in terms of their planning power. Now, I appreciate that document has not yet been published and is therefore not before this inquiry, but it's certainly anticipated that it will be before Scottish ministers take their decision, and the policy will, the intended policy upon which MOD will be consulting reflects the approach which I'm explaining just now about when applications will be removed from the list.
I'm sorry, can I just ask a question of Mr. Milne? Mr. Milne, sorry, apologies if I missed it. Can we just clarify then, if we're saying that the Foresight developer has confirmed that a petition will not be lodged, and fully understand and accept why MOD might not remove the list directly, it was refused by ministers. The 3 months from refusal, the 3 months time bar takes us to the 22nd of this month. So am I right to say that Foresight will be removed from the list shortly after that date?
So, ma'am, if I may respond to that directly. So it is important, Mr. Briggs, to bear in mind that at the moment, what the MOD is seeking to do is apply an approach before it has gone out to its formal consultation on a published document. So it's a published policy document. So it's dangerous from the MOD's perspective to talk about it updating the list in, and we will come on to discuss this in more detail, and I apologise for my answer to a simple question being so long, but the MOD will be consulting soon and will be republishing an updated list in light of that consultation. But to go back to your question, hopefully, it is fair to say that the proposed policy and the MOD's approach in the past would mean that Foresight would be removed from the MOD's list and the seismic ground vibration attributed to it after the 22nd of this month, because the 3-month period for judicial review has expired.
I think that does answer the question. Mr. Collar, do you have any last comments? I'm happy to move on from this. I can understand the party's positions on it. Do you have any final comments you want to make?
Just briefly, Madam, because I don't want to suck us into all of the wider, the MOD's comments there really were predicated on all of the wider issues. So I think Mr. Milne's comments possibly are taking us to your item 28, where you asked what is the MOD's precautionary approach based on? Does the reporter need to take a precautionary approach? So I'm not, you'll be relieved to hear, going to start to answer that. But just to make the point that in my view, Mr. Milne's answer was very much predicated on this is the approach the MOD takes. And we're not here to debate whether or not it's a reasonable approach for the MOD. What we're here to debate is how should this appeal be determined? And the concern the appellants have is a lot of the MOD's comments are predicated on the future policy, what's coming, whereas the appellant's primary position is quite straightforward. There is a consented development. This is a replacement development. The future policy is for the future, and it's not relevant at that point. Now, I appreciate that's the primary position, and there's other issues that kick in, but I think it is important just to remind ourselves that that's the appellant's primary position. And from what Mr. Milne said, the telephone call suggests the issue of what would the effect of a fossil GR be. It sounds as though we will not need to grapple with that, because by the end of this week, we'll, by the sound of it, be clear that it's not an issue anyway.
Yeah, I think that does help clarify that hopefully it's not an issue. And I agree we're constrained to the wider points. I think we can leave that question too. I understand the party positions on that and move on to item 3.
So apologies, ma'am, for interrupting. Would it be acceptable for me to make just a further brief remark on that without prolonging the discussion?
Yes, you can.
Thank you very much. Thank you. It's really this discussion about whether the approach taken by the MOD just now, and separately its intention to consult and publish a policy or approach regarding the safeguarding of the array is a wider issue which is not relevant to the determination of this appeal. Now, the MOD's position is that the safeguarding of the array sits at the absolute heart of the determination of this appeal. And everything that I've been saying so far keeps coming back to that sole aim and need of the Ministry of Defence to depart from a certain approach introduces risk. Ad hoc decision making introduces uncertainty and risk. So I'm afraid by the end of this hearing session, I will sound as if I'm being very repetitive, but the MOD will keep coming back to that position. Sorry for interrupting.
No, I get the MOD's point that the safeguarding of the array is at the heart of your issue and your concerns and how you act. And I think we'll come on to that, because I guess the question is, in my mind, does this appeal prejudice safeguarding of the array based on the evidence I've got before me? So we'll naturally come on to that, I think, as we go through it, when we look at, I suppose, the impact of the development. So if we can move on to item 3, and this was looking at the list of developments which the MOD has taken into account when determining the threshold has been breached. And I'd looked at MOD 018. They kindly provided me with the Annex 1, because the first Annex 1, I thought my glasses were quite good, but I was struggling to see it, that's for sure. And so just looking at this,
So sorry, I will really stop the habit of interrupting you, but there was a final sentence in question number 2. How should you treat the Foresight decision and the noise budget allocated to that wind farm? So I just wonder if that is a point that still remains to be discussed, how to treat the Foresight allocation in light of, we understand, that judicial review petition not having been lodged.
Okay, yeah, feel free to comment on that.
I wonder if Mr. Kohler would want to comment on that first. I'm certainly happy to.
I think Mr. Kohler had commented on the fact that basically, I suppose the noise budget, as far as it's allocated, though I understand it's not an allocation to a specific project, that would kind of go back into the pot, and therefore there would be, I suppose, budget there that could be used for another project, as opposed to Fosside holding on to that. That's what then if Fosside decision had been challenged and redetermined, then it would be redetermined against the context that budget may not have been available to it in the same way it was when the application was first made. That's what I understand Mr. Collar's position is. I guess with the on a pace, if Fosside is not challenged, therefore the refusal is the end of the matter, then my understanding from what Mr. Collar said, his position would be that budget then is sitting available as far as you've got a gap between where you were before that was taken account of and the budget threshold of 0.336.
Thank you, ma'am. Certainly good. If the point is that budget is to continue to use that phraseology, put back into the pot, then that's fine, because there are quite a few questions later on about how that pot would then be used. Really, and that's very helpful, ma'am, what you've just said, because what I would not want to be understood to be the MOD's position at this stage is any suggestion that what had been attributed to Fosside would somehow flow to the Little Hartfell development. And I just wondered if that discussion was going to take place now or would follow later.
I think that will follow later on the basis we're looking at the list and the first past the post policy and whether I could apply that. I think we'll come on to that in the questions as we go through it. So unless Mr. Collar wants to add anything to how I summarise his position, in case I've got it wrong, then we can move on, because I think it is covered when we come on to the list and the application of the list. So Mr. Collar, is there anything you want to add? Because I did paraphrase what I thought your position was.
I'm happy with your paraphrasing. Thank you.
Thank you very much.
Okay, so moving on to item 3. And this is kind of touching on that point, just so I could just totally clarify that when I looked at MOD 018, which is the list of schemes which the MOD have taken account of, if we assume Fosside is final and that's refused, then again, is it accepted that the cumulative amplitude is 0.2878, and therefore that would be below the budget threshold of 0.336. So on that basis, there would be budget remaining. And I'll start with MOD on that point, because I guess it's your document and your process.
Thank you, ma'am. The point that needs to be kept in mind is that MOD 18, and this does sort of leak into your question at number 4.
That's fine.
Is a point in time. That is a list which was prepared or was released. We recollect that in response to my freedom of information request in advance of the judicial review. So that list does need to be treated with some caution. It would not be appropriate to look at the cumulative amplitude immediately before Fosside and take the view that that was somehow inform the headroom available between that figure and the 0.336 threshold.
I guess the MOD at this point must have relied on this list to work out if there was capacity.
So the MOD, in deciding to object to this application, of course, that decision was, of course, taken at the point when Fosside Wind Farm was very much live. We now understand that that decision has been refused and a legal challenge is not to be taken by way of judicial review against that decision. So the MOD, of course, has thought, okay, what are the implications of the Foresight decision for the purposes of development applications which are pending before the various consenting authorities. And the MOD's position is multi-layered. The list is being reviewed again. The technical analysis which is being proposed to revise the MOD's approach and to form a Scottish Government approach is being considered, very much work in progress. The Ministry of Defence and the Scottish ministers are both intending to consult on new policies to give effect to the technical analysis when it's appropriate to do so, and otherwise to safeguard the array. But what is clear against those multiple moving parts is that on looking at developments chronologically, which have been received by the various consenting authorities post-Foresight, the development at Scoop Hill comes before the Little Hartfell appeal application and exhausts the budget. Ma'am, you're on.
Yeah, so I don't think that was what was the case. Can we just stick to this point first, which is looking at MOD 018, disregarding Foresight, there would appear to be budget.
Now, that would be to misapply, unsafely apply what this list is telling us. This is a list which is explaining the cumulative amplitude as calculated at this particular point in time. So the MOD would simply not agree that it is safe to assume that there is any headroom available which would allow the present development to be consented.
And could I just clarify something? I think it's best answered in another question, but we're not saying that the budget that's available for Foresight's refusable is available to the proposed development. As Mr. Collar has stressed, our primary case is that there is a consented development which is next in line, and that the proposed development can work within the seismic profile of that consented development. So we don't say that the budget, as it should be there now, should go to this scheme. As Mr. Milne has mentioned, there are other projects ahead of that scheme, Scoop Hill included. But we're not talking about the proposed development, we're talking about the consented scheme.
Yeah, I understand that point. The point I'm just trying to get to is that, I mean, we're not going to get an answer to it, is that based on MOD 18 and other documents which we can come on to, like APP 8.5, and there's other lists, disregarding Foresight on the basis it's now been refused and that decision is final. I'm not saying it should be allocated anywhere, but just a point of fact, there would appear to be budget between what the cumulative amplitude is, and it does differ between lots of documents, and what the threshold is.
The issue here, again, is certainty and predictability, and the approach that the MOD has taken and continues to take. It mustn't be thought that somehow the judicial review resulted in a shutdown at the MOD in terms of considering applications. But the MOD is continuing to apply a first-come, first-served approach, which language is clearly so important here, is first-come, first-served according to the date on which an application was validated or accepted as valid by the relevant consenting authority. And the application is considered at that point in terms of any available threshold. So the reason I'm being so, I hope ultimately this is helpful, because it is necessary to understand the MOD's position. But because there are a whole string of developments pending in the application process, the refusal of Foresight has not released any budget.
But the removal of Foresight would mean the budget is no longer breached.
It's now breached by Scoop Hill.
Well, we'll come on to that, but removal of Foresight means we're not breaching the threshold, and therefore you then look at your list, take it in 2 steps. The first step is Foresight comes out, therefore the threshold is not breached.
Yes, well, what are the implications of taking?
And then you then look at your
flipping everybody up in the line. Yes.
So the first step is that Foresight is refused, therefore the budget is not breached. Is that fair? I'm not saying how you should allocate it or where it goes. I'm just saying by Foresight being refused, the budget is no longer breached.
And that's where I struggle, because you need to consider what comes next in terms of the safeguarding of the array.
Well, no, just the point. The first point is, I want to know is, if you take Foresight out of the equation, is the budget breached?
I get the opportunity.
But the point just now is that I think that the budget's breached, therefore you have a waiting list. Foresight comes away. From the evidence I've got, it seems to be the budget's no longer, the threshold hasn't been breached, and therefore you'd go to your next stage, which would be to your first past the post, whatever process or policy you put in place. But you don't need to do that at the moment, because there's a waiting list and it has been breached. So I guess it's just that question. If you remove Foresight, my understanding from the evidence is that the budget is not breached. I'm not asking what you do with it, just it's not breached.
So
I have the answer, I think, if it would help, and it's from the MOD's closing submissions on Foresight, which are appellant document 007.001. If you turn up electronic page 34, document page 32, and at paragraph 7.7, where the MOD discusses the prospects of Foresight being able to discharge a suspensive condition if one were imposed on that scheme by ministers, the MOD say, this is a relevant consideration because if Foresight is refused consent, the threshold will not have been reached, and other wind farm developments within the consultation zone may be progressed, subject to obtaining the necessary consent. Obviously, Little Hartfell has a consent.
And we'll put that just one side, just to get this point clear. I suppose, MOD, do you stand by what that says, that the threshold will not have been breached?
So obviously there was a particular debate on a particularly complex discussion taking place at Foresight. So the MOD doesn't depart from anything that it said at Foresight, answering on behalf of the MOD the specific question asked here. The concern is one of being multi-layered. Ma'am, I do understand your question. Foresight breached the budget, but for the purposes of this application, unlike the Foresight application, we're having to look ahead in order to see if any budget is available. And the MOD's position remains that the budget has been breached by other applications coming down the line. Now, I really do want to be as helpful as possible. So if I were to say that if we completely ignored all applications which are pending post Foresight, then that MOD 18 would suggest that immediately prior to Foresight, there was a cumulative amplitude figure which was less than the threshold. So yes, that is what it suggests. And here I have to go into a bit more detail again and explain that whilst that is what that document at a point in time says, Mr. Littlejohn referred earlier to a very considerable piece of work which is being undertaken just now in order to review the baseline. And MOD 18 is an example of the baseline as it stood. at that point, and that was printed off. And the MOD cannot say with certainty that on a review of the baseline and the updating of the data that it holds, that there will definitely be budget available. There might be, there might not be. The array is not safeguarded on the basis of what may or may not be. So whilst I really do hope that I'm not coming across as being unhelpful in avoiding the question, that's not the intention at all. It's trying to give full answers to all of the questions, because the concern for the safeguarding of the array, the primary concern of the Ministry of Defence, is that if we're just to give straightforward answers to seemingly straightforward questions, that could mislead and prejudice the safeguarding of the array.
If I might just add, sorry, Mum, it's Mr. Buckingham, so it's the first time you've probably, well, second time you've heard my voice. In response to that question, being quite succinct, 0.336 nanometers is the threshold. That is agreed, that is not challenged. And using the MOD's current system, using MOD list 018, up to and including Cliff Hope, the budget used or consumed would be 0.2878698, which is less than the threshold.
Okay, I'd like to move on from this one, because question 4, I suppose, also touches on this. And I suppose it's then, we've got MOD 018, there's also lists at APP 8.5, MOD 019, there's tables. We've also got MOD 035 and APP 812, which has got listing and applications, things like that. What weight, if we change the question in light of what we've heard, kind of what weight or which list should I rely on, or can I rely on any of the lists? I mean, I'll start with the MOD on this one, and I'll go to the appellant.
So that's really what I was trying to explain. The MOD is being, if I may say, criticised for taking a precautionary approach. Now, the MOD's position is it is entirely appropriate, given the nature of the array, to be cautious in the decision making and to rely on data when there is certainty. And it's entirely fair, ma'am, to say MOD 18, I've said, has its limitations. It's out of date. It's being reviewed. The appellant's ZI report, Appendix B 8.5, has been revised and lodged in its latest form in terms of MOD 25. That still is work in progress, and Dr. Burrs will no doubt take us through his position on where the ZI work stands when we get to that particular question. So you have to treat all of these lists with an appropriate degree of caution, because work is required in order to give us an up-to-date, accurate, reliable and safe baseline. Now, none of that cuts through the MOD's position that Scoop Hill exhausts the budget. And Scoop Hill comes in before the appeal application. Ma'am, you're on mute, sorry.
We'll come on to this, the Scoop Hill and maybe a bit later on. Is it fair to say, though, and I get what you're saying, they're all kind of at moment in time, or there's all work still in progress, or they're being refined, and I get all that. But is it fair, from my perspective, looking at the evidence I have to try to make recommendations to ministers, that all of these lists would suggest that going up to the point of where the list stopped effectively, which was Forsyth that breached it, with Forsyth out of the picture, the threshold has not been breached. That's what the list would seem to suggest, and that's not then saying I can't put a mark in the sand, because that's all the all the reports seem to go to the point of foci in the way they're, I suppose, looking at measuring the noise, they're looking at taking off the safety factors, looking at background noise, looking at different ways of putting a policy in place, so to speak. So all of these would seem to suggest that up to foci, I'm not speaking about anything else, so it's just a line in the sand, because it will change as you go forward. At that point, taking foci out of the picture, the threshold has not been breached. That's not to say it's not breached now, but at that point, based on the evidence and the reports and the science, it has not been breached. At that point, taking the evidence up to the one before foci, which is called different things in different documents.
That's just to look at MOD 18 at that point in time, and there is significant work being undertaken in order to verify that baseline. For example,
I think, sorry to interrupt, I think the verification of the baseline, the engineering work also seems to demonstrate that the budget hasn't been breached at that point if you take foci out of the picture.
So in that respect, that engineering work is not yet accepted by the MOD. Dr. Burris will explain that, but it is also critically important to understand that the verification, the review of this baseline in order to determine how much, if any, of the threshold has not been attributed to consented or pending development applications, that is not just an engineering exercise. The verification of the baseline, which Montague Evans are instructed on behalf of the MOD to undertake this work, and its work in progress, involves looking at all of the applications which have been granted, and looking at the parameters which are fixed by those consents, and looking at whether the seismic ground vibration which is calculated has been calculated correctly. Frankly, so much has happened in terms of scientific research, in terms of concerns about the management of the threshold, that the MOD is looking afresh at how that list is collated. So there is a real, I really am labouring the point, and that's intentional. There is a real concern of looking at any of this material and just thinking, this tells us such and such.
Mom?
Yes.
Might I be able to bring us back to the question and answer some of the pieces in order for question 4?
Yep, you have your turn, yes, that's fine.
Okay, thank you. So, looking at the list of developments in MOD 18, some of the wind farms have been refused. As Mr. Milne references, there is an audit to be done. The MOD 18 is a list, I believe, accurate as of June 18. The XI work has done an initial pass of this, and I think the work's ongoing, but from, I think it's 004, 003, there's a list held with the XI, and the differences would be the North Lalber has been refused at JR, Glen Taggart has been withdrawn, Kirkpatrick Hill has been refused, Loic Forest, the consent has been lapsed, Watchope and Newcastle Forests have not progressed since 2018, and there's a new site on that ground. So I'm not a planning law expert, so I'll leave that to yourselves. And Harryburn, as you rightly say, has never been included in the latest document. So are either the lists correct? No, both lists would be incorrect. There are a significant number of sites within MOD 18 that should be removed, but as removing 4 sites would create additional budget. And as to which list the reporter should use, based on the currently agreed science as of the 2012-2014 SLMUR working group, which is referenced in the XI documentation 004-003, the currently used precautionary approach is that of MOD 018 table. And if you were to use that table, regardless of whether you looked at the original site or the revised site, there would be sufficient budget based on the current calculation methodology for both sites to be built out. The queuing order is obviously a separate point. So in response to the which list should you rely on, the more precautionary and conservative list is MOD 018. There are a lot of applications in there which should be audited, as that was live of June 18. So which list should you use? I'm happy that you use the MOD's list because it is more conservative than the proposed work package that is ongoing. Thank you.
Thanks for that. Mr. Mill, do you want to respond to any of that?
I think I've covered the point. It's not for a developer. I would very respectively submit to say which list the MOD should use. I appreciate Mr. Buckingham here is referring you to a list that's appropriate, but really it's for the MOD to consider how best to safeguard the array. There is a key point again in terms of the auditing of the list. What is clear from the work done by Zai is that they've removed certain developments which the MOD doesn't consider it's appropriate to remove, at least not before it has consulted on the possibility of doing so. The MOD is very mindful of legal challenges being taken against it because of the risk of simply taking decisions which are inconsistent with previous conduct or indications given to developers. So ad hoc removal of developments from MOD 18, for example, because those developments were only ever at the scoping stage, is not something that the MOD would do without going out to consultation and ensuring that decisions it takes regarding the reformatting of the list are lawful.
So would you agree then that MOD 18 is the most conservative because nothing's been removed from it?
It's not the work is still to be done to get to the most accurate. So I will.
Yes, but I'm not saying accurate. I'm just saying it's most conservative in that nothing has been taken out. There's been no judgment that's taken as to whether it should be in or out. It's just the list as it was at that time. There's been no judgments based on it. So that list is just what the list was.
But it's being reviewed, so figures may increase based on the new approach to how you calculate, not the new science, but a new approach which the MOD is considering regarding how to calculate the SGV based on whether parameters have been fixed within a consent or not relevant to the calculation of SGV. I would look to colleagues and ask if they've got anything in light of this discussion which they think it would be helpful to add. Jim, is there anything that you'd want to add directly from DIO?
Yeah, so the Mod 018 list, it gives data that was, as Mr. Miller said, a snapshot at that time. It may not be complete. It may not provide data of turbine types models that may or may not be more seismically noisy or not. It seems unwise to base any kind of decision on a baseline figure suggested by just adding and subtracting the things from that table without understanding how big room would be created between the threshold and that baseline, which is currently under review from the point of view of the science, currently under review from the point of view of the planning and understanding what developments have been implemented, have been partially implemented, what consents have lapsed. There is an awful lot of uncertainty there, and we don't know how big the threshold, how big the headroom is. So to carve it up and to make claims about how big that is, it is unwise. It's time to introduce the uncertainty. It risks the array.
Okay, just pondering that point. Mr. Collins, do you have anything to add? I'm actually going to maybe just do a 10-minute break here and we'll come back to question 5. But before we do, is there anything you want to add to that question?
Yes, ma'am. Just to really clarify, the point that was just raised. So the science allows a calculation to be made to estimate seismic ground vibration. But that calculation requires input parameters, such as the location, the hub height, and the rotor diameter of the turbines. Hence, those parameters that are being sought to be reviewed in the view that my colleague James has alluded to. And it's those parameters in the list that we would then establish the baseline. So if you like, the science, the algorithm to do the calculation may well be the easy part.
Okay, so for each wind farm, you'd look at the location, the hub height, rotor dimensions, and then from that work out the SGVs, and that's how you need to update the list. So it's the calculation to calculate the SGVs one bit, but the other bit is working out what inputs into that calculation to get the endpoint. Otherwise, the endpoint is a bit meaningless.
Exactly. What we're considering in the latest sort of phase 4 work design is actually making it turbine maker model specific. That's work that's ongoing, and we're still working hard to understand what we're seeing in the data.
Okay, thanks for that. I'm going to give the applicant, the panel, a last chance to say anything on this question 4 before we move on. Well, quick break and then back on to question 5, which will go into this point about agreeing the predicted SGVs for the consented and the appeal proposal. Mr.
Mr. Buckingham.
Okay, thank you. Again, just the clarification. The current system used in MOD 018 uses an algorithm to predict the turbines, or what's classed as a worst case algorithm, to safeguard the array. The work that's undergoing is looking at moving away, as Dr. Bowes says, from that worst case algorithm to an empirical turbine, so a make and model. So what actually would that turbine produce? And in doing that work, which has been ongoing since 2020 in reference to 004.003, which takes you through the various phases up to the phase 4, phase 5, what has been shown is that the turbines, when moving from this worst case algorithm to a turbine, it is substantially smaller in most cases than the worst case algorithm that's currently used, hence suggesting we use MOD 018 as the precautionary approach why this works ongoing.
I have seen the tables in those the design reports that show the SGVs if you use the standard EKA, and then there's different ones for different wind farms and different turbines, and yes, they all seem to be in the main less than using the standard EKA. Okay, we'll pause there. Let's have a 10-minute break, come back at 11:45, and we'll start with, we're kind of going into question 5, but we'll start with question 5, which is looking at the SGVs for the consented development and the appeal proposal. Okay, so 11:45. If you just want to put your camera and your mics off rather than leave the call, and we'll come back on, just put your cameras and your mics back on, that would be good. Thank you. Okay, so welcome back everyone. That's 11:45. Now we'll move on to question 5, and this came out of the statement of agreed matters when the parties requested just an opportunity to discuss the background to agreeing the predicted SGVs and the weight to be given to the appeal documents in light of those agreed predicted SGVs. And at 7.1 of the statement of agreed matters, it was set out there what the predicted SGVs would be for both the consensus scheme and the application. So who's best placed to go first on this one? Is there a preference? Mr. Collar, should the MOD go first, or is it one the appellant wants to start with?
Let's start. Mr. Buckingham's happy to start, Madam.
Okay, that's fine.
Thank you, Madam. So as stated, as you referenced in 7.1, based on the currently used MOD algorithm, i.e. what was used to form MOD 018, the predicted SGV is as agreed 0.13179 nanometers for the present application, and then when the rotor diameter and hub height, as Dr. Bowers alluded to, are the inputs to this, the predicted SGV is raised to 0.16015 nanometers. Would you like any further additional information, or is that clear?
That bit was clear. Just wondered why those figures were slightly different to the figures in APP 4.7.
So this,
I'm looking at the table in at section 3. It's on page 9 on my electronic copy.
Yes, so this is these I reports, which reports both figures slightly lower than that figure. So in the technical work that's going on with phase 4 and phase 5, what we're moving to is a specific turbine, and what we've been doing is effectively predicting a line of best fit. The way the MOD tool, which they currently use as produced by Xi, was run in an Excel format. So we actually restricted the computational power of that algorithm. So we applied that approach when producing that report, which excluded a very small amount of additional budget, which Dr. Bowers has discovered. It represents a 0.09% and 0.36% difference, but I'm happy that the slightly higher figure is correct.
Okay, so we're happy to go with those figures in the statement of agreed matters with the explanation behind your report. Okay.
Yeah, a mathematical simplification for Microsoft was used, which means you get a very small difference.
And there was this point around the weight to be given to the appeal documents in light of the agreed predicted SGVs.
In terms of the principle of the documentation, if you were to take either of those calculations, i.e. the slightly higher agreed ones, it doesn't change the principal matter that the site, as originally granted, there would be sufficient budget for it. If we're to use a similar approach to 20 shilling, you would be able to bring the revised scheme under that original budget.
Okay, there's a slight string on to the next question, but actually the revised scheme using the standard EK is slightly more.
Sorry, could you repeat the question?
The revised scheme using the standard EKA analysis is more than the consented scheme.
Yes. So that is those two agreed figures. The consented scheme is the 0.13178 nanometers, and then the other scheme is the 0.160, using the MOD's worst case algorithm as per the 2018 list.
Okay.
Madam, just a quick, easy point to explain. The note in the SUAM was directed at what you've picked up in item 7, I think it is, in the agenda. It's later on. So
Okay.
in case you were wondering what that was pointed towards, you have, as I say, picked it up, but it's later on in the agenda.
Okay, well, I can leave this point here just now. I mean, you've clarified what's been agreed for the SGVs for both schemes. I guess maybe understand just at this point, and it comes back to this microsighting point, really, how critical. I think the distance is critical, because I saw, I think it's in MOD 006 or APP 4.3, that one turbine 10 kilometres from the ray is the same as, I think it's 80 turbines 50 kilometres from the ray in terms of impact. So clearly distance does have a considerable impact or consequence to the impact on the ray. But in terms of microsighting by 100 metres, how critical is that when you're looking at these kind of figures?
Might I just respond to your first point? You said one turbine at 10 is roughly 80 at 50 kilometres, is that correct?
Yeah, I think it was 80 at 50 kilometres, yeah.
It's quite complicated math, and it's very dependent on the type of turbine.
Okay.
But one turbine at 10.2 kilometres for a specific make and model would be equivalent to over 5,000 at 50 kilometres.
Oh my goodness.
Distance does play a significant role.
Okay.
Microsighting, so the inputs to the SGV are the location, i.e. the distance from the array, the rotor diameter and the hub height. So microsighting would make a difference, but something that is entirely calculable and well known.
Okay. Okay, Mr. Milne, anything you want to add just on this point about the agreed SGVs and the way to be given to the appeal documents?
Thank you, ma'am. Not much really, although I'll hand over to Dr. Bowers in a minute, just in case he's got anything to add by way of response on the technical side of things explained by So really the key point, and again, is to ensure there's no misunderstanding. Sorry, apologies, it's Dr. Buckingham, isn't it? I didn't mean that in any offence.
Thank you.
These things matter. In terms of question number 5, what I did want to make clear is, whilst the predicted seismic ground vibration, the output of a model, the agreed figures are just that. There's no suggestion in that agreement that somehow there has been an allocation by the MOD to the consented development planning permission, but that I think we're going to cover in more detail in question number 7.
Yeah, this question wasn't trying to imply that at all. It was just to get to the point that those figures are agreed between both parties. Yes, and so Dr. Bowers, is there anything that you think would assist the inquiry in terms of discussion you've heard about question number 5?
Thank you, ma'am. So I agree with Dr. Buckingham's explanation. It is indeed around 5,000 times more, between 50 kilometres and 10 kilometres. And I would say the way the functions in the algorithm are constructed, the sensitivity to microsighting becomes more critical the closer you get to the 10 kilometre exclusion zone. So the difference becomes larger the closer you are, in general terms. I think perhaps an important lesson from the implementation in 2014 of the XI 2014 model, where the technical point is they only deal with a certain number of bending modes, multiples, from the blade passing the turbine tower. But I think we didn't notice this, the effect of their, is what Dr. Buckingham refers to, sort of limitation on the implementation, because of the turbine types we were looking at that time. We were dealing with much smaller turbines than are now being constructed and put in for being proposed for development. And this is another reason why it's worth re-examining the 2014 so that it's sort of fit for purpose moving forward. And this is turning out to be a little bit of a challenge, but we're working on it.
No, I get. I mean, turbines have moved on, height, technology, everything else. So I get all that. But I suppose the point is we're all agreeing those figures for both the consensus scheme and the appeal scheme. And just on that point of 80 turbines, just so I'm not going mad, it is in a PP 4.3, page 7 of the PDF. If it's 5,000 turbines at 50 kilometres, then, and that seems to be agreed anyway between the parties, I'm happy to, it just gives an indication of how critical the distance is.
There might be. If it may assist, just in terms of the uncertainty and concern in relation to the microsighting point, we'd be more than happy to control microsighting through the microsighting condition, such that no turbine would be permitted to be microsighted any further in the direction of the array. That would just take that element of risk away.
And on the point of the turbines, yes, we're agreed. It's make and model dependent, but as a rule of thumb, I think one at 10.2 versus 5,000 at the 50 kilometres is certainly a number we could use. I'm sorry, ma'am, you're on mute.
Sorry. I'm just going to speak about that condition that you're suggesting, that there would be microsighted no closer to the array. From the MOD's perspective, I assume in principle that would allay some concerns in that the impact shouldn't be any worse because you're getting no closer.
That would make sense. I think whether there isn't an allocation of budget.
I get. I'm not trying to attribute budget to anyone at this point in time. It was just the principle of looking this in little isolation, this little condition. That's what it said.
Very happy to look at that.
I wasn't trying to imply anything about the budget allocations. Okay, so that's, I think, question 5, unless anyone's got anything they want to add on that point. Question 6 is maybe something I don't even need to get into. It was just, there was a point was made in the appellant's hearing statement, and it's maybe something it's totally relevant to this case. It was due to the Forsyth decision and the model updated by new Q and V values, which doesn't apply here. And maybe if that's the only thing I need to take from that, but it doesn't apply here, that in itself would just be helpful. So I'll start, because it was in the appellant's hearing statement, I'll start with the appellant. If that's you, Dr. Buckingham.
Thank you, ma'am. Principally, I think if you just step back from it, the XI work has always been about quantifying the amount of vibration coming from a turbine. The Foresight work strayed into how that propagates through the ground. And as Dr. Bowles is the UK's chief forensic seismologist how waves travel through the ground, I will let him be expert on. But we are not challenging, as Foresight did, the fundamental science of how the vibrations get to the array. All we're doing is quantifying how quiet a wind turbine is, how much the source term. Does that make sense?
Yes, that does make sense. And on the basis that I think the evidence that I've got is this quantifying of the vibration, not really disputing that the vibration then travels. I'm assuming the Foresight has little relevance, this Q and V values, because that's not been challenged. That's not the case either party's made in this case. Is that fair?
Yeah, that's right. We're happy to use the existing safeguarding algorithm to demonstrate there's sufficient budget headroom available for the consented development.
Okay, yeah. I mean, Dr. Powers, do you want to add anything to this, or is it something that I need not be overly concerned about?
No, thank you, Mum. I don't think you need to be concerned about it. We have mentioned it at length, but I would just add that it is that propagation term which leads to this large difference in the predicted impact of a turbine at 10 kilometres versus a turbine at 50 kilometres.
Totally, I get it from that perspective.
It's that propagation, yes. And it's also the fact that we assume that the source term, which Dr. Buckingham referred to, essentially, if you want to double the impact turbines at the same distance, you need 4 times the number of turbines. So it goes as the square. The ground vibration amplitude displacement goes as the square root of the number of turbines of common distance. So that's how the scaling works. Just to give you an insight into how all these terms are.
Okay, that's helpful. I think Foresight is a different scenario and argument compared to this case, which is based on, I'd say, the standard EKA modelling. Okay, on to 7. And this is kind of, I suppose, flowing on from the question about the SGVs. And the point I was just asking here is it correct to say that the proposed development can be constructed and operated without exceeding the seismic impact of the consented development? Because I noted that the appeal proposal is more slightly than the consented development, and therefore I wonder, is it correct that the appellant said it could be operated without exceeding the seismic impact, and then is that difference material in relation to the 2 schemes?
Thank you, ma'am. So as we discussed the ongoing work, the current transition, and also this move from this worst case algorithm to what a turbine actually emits. So if we're to take the current budget allocation methodology as used to create table MOD 018 and apply that to the consented development, that would give us the figure of 0.1316943 as agreed in the 7.1 that we just referenced. If the same approach as 20 shilling wind farm was taken, i.e. evidencing to the MOD that a specific wind turbine make and model could fit within the budget calculated by this worst case algorithm, yes, the altered scheme would fit within that original budget. I'm not sure I made that super clear, so I can clarify it.
No, if I just clarify what I think you said then. So the consented scheme based on the standard EK modelling gives you that figure of 0.13179. And if you model the appeal case based on a turbine, specific turbine, you could get it to fit within that budget, so to speak. Is that if I understood that right?
Yeah, absolutely correct. You could take a number of turbines, different makes and models, and you would be able to find a turbine that would fit within that original.
And it's just looking at the document, and I took that from, I think it was APP 4.7.
Yes, that's right.
When you've got the two standard EKAs, which is where you've got those figure or similar figures, those in 7.1, and then you've got the list of looking at different turbines, and then the direct measurement at the very bottom.
Yes, I would highlight there may be some of that minor rounding error in there. I've recalculated them since, and they would fit within that budget. So.
So when you're saying that, the appeal scheme fits in the consented scheme budget, it's kind of not comparing apples and apples, but you could get to fit within the budget when you base it on looking at turbine models.
Yeah, so just to maybe step back very slightly, the original budget calculations the MOD used were in 2005, which used the MOD 004. They ran that system up until the budget was exhausted. We then did some work between 2012 and 2014, which created the knowingly conservative algorithm that the MOD currently use, and that was used. So in that transition, it freed up over 1 gigawatt of onshore wind. We've now used, the MOD have used since 2014, the algorithm, which gives you the figures in MOD 008. Now, the industry since 2020, there are a series of documents, MOD hours at 004.003, which in the first instance said, if we look at this worst case algorithm versus a wind turbine, would there be more budget? The initial study said yes. And then we followed up with these subsequent studies to where we are now with phase 4 and phase 5. And we're in the final, well, the MOD are currently reviewing these, and the industry is, in order that we can transition. But I think a point is 20 Shilling wind farm specifically adopted the same approach with an agreement to the MOD. And that principle would work in this case.
Okay, we will come on to 20 shillings. I've got questions about that. But just on this question 7, MOD, anything you want to say in response to what you've heard?
Thank you, ma'am. I'll hand over again in a minute to Dr. Bowers to respond to what Dr. Buckingham has said, in particular in relation to this suggestion of using a specific make and model of wind turbine to operate within the seismic ground vibration of the consented development planning permission. It's really all that I wanted to say, and I know it's going to be developed through further questions, is of course question 7 proceeds on the basis that there is a budget allocated in respect of the consented development planning permission upon which the appeal application can rely. Now, of course, the MOD's position is that the consented development planning permission was allocated no budget at all. There is nothing available for the appeal application to rely upon. And of course, the MOD's reason for that is that the consented development planning permission was subject to, granted subject to a suspensive condition, which required the impact of that development, the adverse impact of that development on the array to be mitigated. So really the appellant's case, the MOD's position is proceeds on that false premise.
Okay. So I guess in terms of the prediction and the models that Dr. Buckingham has presented, the appellant has presented in 4.7, this is on the face of it fine, makes sense, needs refinement, I agree. But there is a wider concern here which maps into, I guess, the ongoing review of the substantially refined phase 4 work that I guess I'm being asked to do on behalf of MOD. And that is that the turbines that have been measured in the phase 4 and previously essentially have hub heights of up to 80 meters. Where we seem to be going in the future and in this appeal is for a turbine with a hub height of 115 meters. And we're now entering into a realm of extrapolation, and I think I need to have considerable thought and probably considerable consultation with experts at SAI to try to understand what is required. We can get to 20 Shiny Hill later, if that's okay. So that's what I wanted to say is the data set on which the phase 4 is based is really good at helping to understand what has been built in the consultation zone and its seismic ground vibration. But it may not be good for extrapolation, and that part needs some thought. And that's on the science side, putting aside, of course, the concerns and the work, considerable ongoing work in deciding what parameters are needed for the developments in the list to determine this baseline.
Okay, and sorry.
Sorry, Mom.
Yeah, just come back on that.
Yep, certainly. Obviously, technology has moved on. They do get larger as they're more efficient cost-wise. But what we would state is that the appellant would happily measure the turbine that would be due to be installed at the site in order that confidence for the absolute levels and remove the need for extrapolation.
Sorry, and you'd suggest that as a condition. Is that what you're saying?
If the MOD required confidence opposed to extrapolation, a measurement of the specific turbine to be chosen could be done prior to installation on site. Yeah.
Any comment from the MOD before we move on to question 8?
I don't think so. Of course, the suggestion of a condition doesn't overcome the fundamental issue that there is no allocation.
Yeah, no, I get that from your perspective. Yeah, I wasn't trying again to suggest that. Just for one point in this question 7, I think in the MOD representation that was sent to the DPA, it was said that the appeal scheme would is materially different, and I guess that's because the height is materially different in your view, and would result in increased seismic impact on the array. And is, I suppose, you're trying to suggest there that the increased seismic impact would be materially different, or just that the scheme is materially different?
The scheme operates, it's proposed to operate under different parameters which are relevant to the prediction of seismic ground vibration, and that's an important point to make. It is in that respect is a different scheme, and also in terms of materiality, the point that was being made is that the Eskdale-Muir threshold, this 0.336 nanometers, is a finite resource, maybe unique in terms of environmental assessment and the approach to be taken towards the safeguarding of the array, and when considering the risk of a breach of that threshold, any difference in seismic ground vibration can be material as you approach the threshold.
Okay, Dr. Buckingham, do you have any final comments on that? And then I'm going to move on.
No, thank you.
Okay, question 8. And this was, if the first past the post method of allocating budget was used, is it agreed that the consented development, not the appeal proposal, but the consented development would be next in line? And it seems to be the case that it would. MOD 035 might be the easiest document to go to, which is based on APP 8.12 with more information. I'll go to Mr. Milne first on this for MOD, or anyone in your team. So is it agreed it would be next in line?
Thank you, Mark. This is, of course, a very material question here. The MOD's clear position is that the application, which is before you and Scottish ministers, is not next in line. Looking at MOD 35, we see Fosside, which is, of course, then followed by what we're referring to as the consented development, the one which was granted subject to a suspensive condition. That's next in line, but we don't get to the appeal application until the number 32. So that's really the sort of simple sort of what's next in line.
Sorry, the consented scheme is number 2 in your list.
Yes.
And then, on the next page, you've got number 32 is this current appeal.
That's correct. Now, of course, again, language that's being used, the MOD, of course, noted that this question talks about first past the post method of allocating budget. Now, the phrase always used by the MOD, and that it is continuing to apply in this phase before it consults on a new policy, is first come, first served. And that has very much been according to, as I said earlier, the date of validation of a planning application, or the date on which a Section 36 application is considered to be valid, and their English equivalents. I'm not sure if you're intending a difference by using first past the post. The MOD has found itself at public inquiries previously where developers have, for example, suggested that applications should be allocated budget at the point of decision making, as in the consenting authority deciding whether or not to grant planning permission. Lots of ideas have been mooted in the past, and the MOD has said uncertainty, unpredictability.
No, I was taking your approach. As I read from the documents, that I was assuming when I meant first past the post, it was first come, first served. So it was those that come into the system in the order, not those who get consent. So I think we're saying the same thing. Yes, I'm not. Yes. That was my understanding. I'm not looking at it as when things are determined, it's first come, first served, or first past the post. At that point, it's as they come into the list, as you say, whether it was an application being validated, you've got scoping in there, you've got applications coming in as a Section 36. So I was taking the same approach as you've outlined, not the decision at the end of the day.
Thank you. That's very helpful. Thank you. I didn't want a misunderstanding to keep in through very slightly different language.
Yeah, no, it was helpful to clarify that.
In terms of just again to ensure that I'm being very clear, what the MOD has done historically is deal with first come, first served on the date consultation received. What is likely to be proposed in the policy consultation going forward is date of validation, or date on which applications are accepted as being valid, depending on the type of application. So variations of first come, first served.
Okay, but based on this, the consent development would be next in line, not allocating budget, but it would be next in line on this form. And I suppose just leading on from what you said there, that the future policy would be data validation rather than a data consultation, would it still be this first come, first served principle?
That's very much the intention. That's obviously the consultation document is still to be published, but that is the intention. And I would say there that in terms of the judicial review, and ma'am, I appreciate you're aware of this from the papers, but the judicial review which was sought against the MOD's safeguarding approach was a challenge to different types of application being treated differently. Issue was not taken with first come, first served.
No, I noticed that. It wasn't actually the principle first come, first served. It was how you identified at which point an application should be treated as first come, first served. Yes. And the lack of transparency around that and the irrational approach around that. So I get the point. It wasn't the principle of the approach. It was how it was being done was the issue.
Yes.
Okay. Does the appellant have anything they want to add to this? Mr. Collar, Dr. Buckingham?
Yeah, I've got a few points I can add. So if the question was, is it agreed that the consented development would be next in line? And that's the consented development, and the answer is yes, it is. It doesn't really matter which list you look at. Little Hartfell, the consented scheme, always comes top of the list following Foreside. There's three kind of main points that we've put down to kind of back up that position. It's helpful to hear that the first come first served policy is intended to continue with the new policy. It was certainly the case that first come first served was in operation at the time the consent development was applied for in 2018, and in the SOAP, the MODs agreed that that policy continued until at least 2021. So that's the system that Little Hartfell was put into. The second is that obviously when we submitted the JR challenge, we sought two different things. The first was that was a confirmation that the allocation policy, which allocated budget to different projects at different stages, was unlawful, and we also sought reduction of the waiting list. We were successful on both points in the outer house, but then the inner house judgment overturned the reduction of the waiting list. So the waiting list still has the same legal position that it had prior to any of the legal proceedings. And the relevant document is appellant document 008.012, and that's titled Estelle Muir Consultation Since Budget Breached, and that's referred to in the inner house judgment. That was before the decision makers at the time that judgment was made, and you see that Little Hartfell is top of that list after Foreside. And then the third point is just to pick up again the Foreside closing submissions from the MOD, where it was stated as earlier that if Foreside is refused consent, the threshold will not have been reached, and other wind farm developments within the consultation zone may be progressed, subject to obtaining the necessary consents. And that's basically the main part of our case, and that's what should be happening now. Budget should be flowing to the consented Little Hartfell development now that Foreside has been refused. It's top of the list. It was put there according to a first come first served policy that was in operation until as recently as 2021, but is seemingly going to continue to operate. And that can all happen under the current predictive model. No changes need to be made to the model or to the science which underpins it to allow that allocation to flow to the consented development. So to summarise that, I'd say the MOD says that when Little Hartfell was submitted, it was managing the budget on first come first served, and that continued for a long period after Little Hartfell was submitted. The waiting list, which is Little Hartfell at the top of the list, still has legal status following the inner house judgment. And the MOD has said itself at Foreside that if that scheme is refused, then the threshold will not have been reached. Other wind farm developments in the consultation zone may be progressed, subject to obtaining the necessary consents. Well, we've done that. We've done the hard part, and we've got the consent at Little Hartfell, and budget should be flowing to it. The kind of wider and more basic point is that obviously the allocation of the budget to foresight at scoping stage was found to be unlawful. That was the whole point of the JR proceedings. Little Hartfell was the first application to be submitted after the foresight scoping had gone in. So the budget that Little Hartfell should have received, because that was a planning application, should have received had the allocation policy been operating lawfully, was not given to it. Instead, it went to foresight scoping. So Little Hartfell has been disadvantaged really by the unlawful operation of that policy, and has been prevented from coming forward. And we're now in the situation where foresight having been refused, the budget that should have been allocated to Little Hartfell in the first place, had the policy been lawful at the time, is once again available. The waiting list still has legal status, so we say it should be coming to Little Hartfell.
Mr. Milne?
Thank you, ma'am. As I've explained, the MOD's position is that Little Hartfell, the consented development, I suppose a simpler way of putting it is it's not on a waiting list. It has been determined 3 or 4 years ago, and it was determined on the basis of no allocation of budget to it. It was determined on the basis of a suspensive condition, which required a mitigation agreement to be entered into regarding adverse impacts on the array. So the MOD's simple case is that an application which has been determined cannot be next in line. Further, the MOD has never, in operating its first come, first served, considered the retrospective allocation of budget to developments which have already been consented. Little Hartfell here had no allocation, and what appears to the MOD to being requested is that it is now, 3 or 4 years later, allocated budget which it is said has become available. So that really must be borne in mind. The MOD is intending to consult. In addition to never having engaged in retrospective allocation of budget, that's not intended to be suggested in the forthcoming policy. It must be kept in mind in terms of the appellant here is talking about unlawfulness. The MOD very much has to bear in mind that if it is retrospectively to allocate any of the headroom which is said to be available to the consented development planning permission, despite the suspensive condition, Mod 35, the production, shows us that there are a number of applications sitting there who would no doubt have something to say if any available headroom was to be handed back to the consented development planning permission.
Okay, I think you've lost me a little bit. Why can it not be next in line?
It's been
So you're kind of saying that because that planning application was determined, it somehow then comes off the waiting list.
It's not waiting. It's been granted subject. We can't just ignore the suspensive condition.
Mr. Milne, the waiting list isn't a planning determination list. It's a waiting list for budget. We are waiting for budget.
Well, should explain as well that since the judicial review, the MOD has not operated a waiting list. What it has done is kept a note, mindful of what the Inner House explained in its judgment. The MOD has kept a list chronologically of applications which have been intimated to it.
Mr. Milne,
The MOD doesn't
sorry
see
to
that.
interrupt.
Sorry, the MOD doesn't see an entitlement there. And the fact of the matter is that the MOD did not allocate any budget to this development.
Mr. Milne was not able to allocate, budget to the development because it unlawfully allocated it to Foresight. We've been waiting in the aisles for 6 years. Why, next in a waiting list, which was put together to queue projects as and when budget becomes available in the future, and that was 3 years until you stopped that approach, the outcome of the JR. Why, if MOD's sole concern is safeguarding, which everyone would agree it should rightly be, would MOD keep budget allocated to a project which no longer exists when there is a planning consent which is ready to go and is next in line for that budget? That in itself feels like more of a safeguarding risk.
I've explained what the MOD's position is and how it's operated and what it has not done in the past, and it has not gone back to already consented developments which were granted on the basis of conditions which required adverse impacts on the array to be mitigated. If there's an application which had not yet been determined, that would be a different matter.
But does that not take us to the inevitable, just because you've not done it that way, doesn't mean you were right to approach it that way? A lot of the discussion seems to be predicated on the MOD must continue to approach things the way the MOD has always approached things, irrespective of the rights or the wrongs. That seems to be the answer we're hearing time after time today.
I think the answer that's been given time after time is that the MOD is seeking to act in a consistent manner and a predictable manner, and in a manner which safeguards the array.
Well, I hear that, but it could be consistently wrong, is what I'm saying, because you do not seem to accept that a different approach can be taken. And I get that's because consistency is important, but continuing to take an approach which isn't necessarily the right approach can't be the right way of doing things either.
And what the MOD is, and I've said this multiple times, the MOD is intending to consult on a formal published policy, and no doubt we'll hear right across industry if industry and other stakeholders do have alternative suggestions, and no doubt the MOD will fully consider those before it promulgates a new policy. Again, I'm being very careful to explain that the intention is to consult, and I'm outlining what the MOD's proposal will be there. That's not to suggest any foregone conclusion on the matter.
Sorry, can I just get back to this point about how it cannot be next in line? Because that just seems to me inherently at odds with what I was thinking, because it's almost penalising the project for getting consent.
Ma'am, can I just make a very small point on?
Yes.
Before you, I'm sorry to interrupt. It was just following on from Mr. Milne, where it is prosed on about emerging policy. It was just a point on, and obviously the appellant is a big part of the efforts to bring forward new allocation policy. But the pertinent point here is that there's no suggestion from the working group and ScotGov that emerging policy, when it becomes policy, will apply retrospectively to projects that have consent. In fact, the opposite. The Scott.gov are on record in the appellant 008.011, page 3, third paragraph. It states that future policy will apply to all applications yet to be determined. So there's no suggestion. There certainly needs to be policy coming forward for sure, but it is not the case that it will apply retrospectively to a project which has proceeded in good faith and in reasonable reliance on a budget allocation. It is next in line for budget according to a policy which was in place till 3 years after the application was submitted. And just as an academic point, even if it were subject to emerging policy, whether Mr. Milnes indicated that would be awarded on planning consent, well, under whatever new policy scenario, allocation policy, and it must be across the board per the judicial review decision, whether you allocate budget to projects at scoping stage, application stage, or on planning consent, Little Hartfell is next under all those scenarios. I don't see why budget isn't flowing for Project Next Online in case it disadvantages projects that are further down the list.
Mr. Milnes, do you want to comment on that?
Really, it's just to confirm the MOD's position is that the consent to development planning permission has been granted. There's no suggestion that a new policy will apply to that. That application has been determined, and the local planning authority granted planning permission subject to a suspensive condition to require mitigation. That's a fact. That's what happened, and that application is there. Now, as for the policies coming forward, Scottish Government and the Ministry of Defence, they may apply to the peasant appeal application, depending on when those policies come out, what they say, and the stage that this process has reached.
So, Mr. Milne, can we agree that Little Hartfell will not be captured in future allocation policy? Is that what we're saying?
Well, I certainly can't speak for the Scottish Government. And
but as far as the MOD is concerned,
I can't say what that policy. I can't prejudge what the consultation will say.
well,
I think it's quite standard for a policy consultation to explain when it will come in. A policy consultation to say when it's anticipated that a policy will actually come into.
Sure. But when the Scottish Government says that it has no intention to apply new policy to projects with planning permission, you wouldn't seek to argue with that position.
I've got no comment on the Scottish Government's position, really. Obviously, here representing a department of the UK government.
Okay. As I say, the point stands. Whether a new or whether new policy applies to the consented development, or as we say, the approach that MOD was had in place at the time Little Hartfell was submitted. Under either policy, and we say it's old policy, Little Hartfell is next in line for budget.
And just on that point, is the MOD's position now that Little Hartfell consented development is not next in line?
Correct. The consented development planning permission
Is not next in line.
No, it's been determined.
What's the interaction between planning process and the waiting list for budget?
What? Sorry, you cut off as you were saying that. Sorry.
What's the interaction between planning permissions being granted and a list which orders projects in chronological order according to when they were which puts them in line for budget. The fact that it has a planning permission did not alter its position in a queue for seismic budget.
One would have thought from a safeguarding perspective, having a consented development within the consultation zone that was top of the list, removing it from the list so that it's outside of the list because it had consent, and surely that introduces a greater safeguarding risk to the array, because then you're completely out of control of what happens to allocation of budget to that project.
I suppose equally, or is it inversely, the foresight is also a determination. That's staying on the list.
And the thing about this conversation is that this is what highlights the concern from the MOD's perspective, because the MOD has not operated a safeguarding approach on the basis of leaving consented developments vying for any budget which becomes available. Because for my part, on behalf of the MOD, I really struggle to see how that actually works. When could a development come forward, for example, and look for additional budget that it needs? There is a real problem with making up, with the greatest of respect, a new approach in the context of a particular appeal.
Oh, it's the opposite. We're not advocating for a new approach. We're advocating for, in your own wording, a consistent approach to safeguarding the array, which is the allocation policy in place up until 3 years after Little Hartfell should have had budget.
My simplistic view of this was that you have this waiting list. At the point there becomes headroom, the one next in line would then come, whether it had plan permission or not, I suppose in the case of Little Hartfell, come with a plan permission to try and get their suspensive condition removed on the basis that there was headroom. Not that it would be free for all these planning consents were here, ad hoc coming in with suspensive conditions, and that would allow you to kind of say to other applications, well, actually, you're not next in line because here's our list, and that's how we're going to look at them in accordance with that list. So I thought the list still had a basis, regardless of whether developments were consented or not, because that was the basis you would fairly, from an MOD perspective, look at how the budget, whether it was going to be breached or not. So you can keep it in there. So I get the fact if Swaside is refused, it comes off the list, and then if someone else on the list had been refused, it would come off the list. But then the ones that were in there and were consented would remain on the list and get the first chance at some budget. Otherwise, I think you are getting in. I mean, that was my understanding. Otherwise, it feels like it's totally ad hoc and inconsistent.
Which is not the MOD's view on this at all. So
is this like saying then that Little Hartfell's consented, it goes to the end of the queue, or?
Ma'am, this is where the MOD's a bit confused about this suggestion. Little Hartfell was granted consent. It's consented subject to a suspensive condition which requires it to mitigate the impact on the array.
Mm-hmm.
Mr. Milne, does that not dovetail in quite nicely to paragraph 7.7, Pellant 007.001, a point Mr. Briggs made earlier? Electronic page 34, paragraph 7.7. And I quote, "This is a relevant consideration." This is talking about foresight condition, because if foresight is refused consent, the threshold will not have been reached and other wind farm developments within the consultation zone may be progressed, subject to obtaining the necessary consent.
And don't think the MOD would depart from that. That's not what is happening
Well,
here.
fine. Little Hartfell has consent and is next in line.
That's not how the MOD has operated matters. It has consent. Therefore, I mean, another way perhaps of describing this is the way the MOD has operated this, and it's trying to strike a consistent line here, is when an application comes in, it is there's a certain amount of seismic ground vibration attributed to it, based on the application of the 2014 predictive model. If there is no budget available, there is an objection. What happened here is what ultimately gave rise to the consented development planning permission is it came in, it was objected to because there was no budget available. It was allocated no budget. That was the decision which was taken. If you had a situation in which an application had come in when there was budget, that would be when the MOD did operate a waiting list, the application would have come off the waiting list, would have been put onto the list of developments which had then been consented, and that would be on that statement of the MOD's position from which the cumulative amplitude of consented developments could be calculated. Here we have a situation in which there was a decision by the MOD to object because there was no budget. The MOD advised Dumfries and Galloway Council and said, there is no budget available, we object. The application, however, was granted subject to a suspensive condition, which pejoratively said, you need to deal with that seismic ground vibration. And that was the determination. So I think it's fair to say that the MOD doesn't understand how a development which has been consented could be sitting there waiting to take up further budget. What if there had been multiple developments all granted on the same basis, subject to suspensive conditions, which said if some budget becomes available, you have to allocate them, we get first dibs on that. There's another way that matters could be characterised following this discussion. And that's something which came up in previous inquiry, and the MOD explained that putting things at the end, allocation post-consent, results in a real concern for the safeguarding of the array, because there are 20-odd consenting authorities, all with jurisdiction over the array, and are they going to be invited to consider the retrospective allocation of budget in terms of when applications are consented?
Is that not a reason to have the waiting list? So when a party comes in to try and purify their condition, you could say, you're not next, and you don't get this ad hoc allocation at the end of the process because you're still referring to a waiting list, so the MOD still have control.
It might be worth pointing out that it isn't a waiting list for budget. That's not what this list is. It's a means of understanding how we respond to consultation as and when applications or as and when we consult on a given scheme. We can only respond given the variables, the material considerations in play at that time, and we would make a recommendation or make a consultation response on that basis, whether we object because there's no budget left, or when budget was available, when we were able to calculate it for a given scheme and agree to or put no objection on that basis. That's how this is. That's the list and what it does.
It's a list whose existence and ordering was preserved in law up until 2021. The outcome of the appeal to the Inner House. So, and that's the list we're at the top of. So, but I come back to this retrospection point, Mr. Milne. You mentioned applying, allocating budget retrospectively. It's not a retrospective allocation of budget. It's allocating budget. Now it is available once again, according to the allocation policy, which was in place and preserved in law at the time that Little Hartfell was submitted a planning application. So that's the first point. And the second point, safeguarding. Why when we know that MOD is concerned about a suspensive condition as a principle. So is it not a concern then that a planning permission exists with a suspensive condition? And if it is, now that budget is available and that project is next in line, why should not budget flow to it?
Because that's never been the MOD's approach.
Always been the MOD's approach.
That's your. There's really a discussion between us, but it's. There's clearly a difference of opinion on what the MOD's approach is, and the MOD's position on its approach is that's not how it has operated matters.
Well, I'm just citing MOD's.
Or the term waiting list is used in a misleading way. The phraseology around the safeguarding of the array budgets and allocation and waiting lists has always given rise at inquiry to parties implying meaning to the MOD's approach, which doesn't reflect how the MOD has actually managed matters.
I guess the point I was struggling with is if it's a first come first served basis, and that's based on validation of plan application 636, and that's still the intention, I don't understand why you come off that list just because you get consent. You're kind of going into, I suppose, a planning process assuming one thing, in that you're on a list, a waiting list, whatever you call it, and therefore entitled to some allocation at some point according to where you're on that list. Yet when you get consent, the goalposts suddenly change and you're off the list. It just, the two don't seem to sit very well in my mind.
The suspensive condition refers to mitigation.
We've submitted an application to purify that condition on the basis of there being budget available. That's the mitigation scheme.
And that application's pending. And the MOD has.
I don't think we're going to get any further with this discussion. To me, it just seems a bit odd as to what the MOD were kind of saying on the first come first served basis. Yet you get planning consent and you're kind of pushed to one side off the list, and then you want to go and fight for your budget. And it may be because MOD haven't been in a situation before where the next in the waiting list, there was no budget when it's got consent. I don't know, but it just seems to be slightly odd with what the MOD are saying is their approach, and then there would seem to be a gap between these ones on the list and anything new that comes in when the new policy comes into place. So kind of what happens to these ones on the list?
So
are they kind of start back and fight for the right? It just seems there's a gap there between the two.
Bearing in mind what Mr. Horton said about it's not a waiting list, there isn't. Parties shouldn't be sitting there thinking we've got our consents, but if we need some of the headroom, then we can claim that when it becomes available. That's not how matters have ever been applied. Now, the fact of the matter is that the consented development planning permission has been granted. If it had not been granted, the situation would be different. But it was granted subject to a suspensive condition, and the Ministry of Defence is very mindful of that. Now, later in the agenda, the Scottish Minister's policy, and certainly in the appeal documents, is referred to, and that may also be relevant in terms of what happens next, because, and I appreciate it's not for me to go in, certainly not just now, to that in great detail, but the intention there is to look at any budget which has not been attributed to a consented development, and for the ministers, Scottish ministers, to consider from a planning perspective whether better use of that budget can be made in terms of maximising renewable energy generation in the consultation zone. So that's not retrospective otherwise than in relation to developments which are still in the system unconsented. I think it is worth bearing that in mind when we're looking at what may happen next.
Where I'm looking at the SMUR interim guidance, which is MOD 005, and this is the interim guidance for how MOD is going to safeguard the array. And so it kind of states, I think it's the fourth paragraph, with regards to future safeguarding arrangements, the SMUR working group has concluded that the MOD's current safeguarding approach, whereby developments are considered in chronological order as they are notified, remains appropriate. And so I guess I just don't understand how you suddenly come off the list if you're trying to protect the array, because surely ensuring everything's on the list allows you to have some kind of control and manage that list.
But application here has been determined on the basis of no allocation but mitigation. There isn't.
But why is that? I suppose why is that relevant to the MOD on the basis that it's still a project in chronological order, and it'd be up to that development to satisfy you that either this budget or a mitigation can be mitigated.
It comes back to allocations have been made at the date of intimation of the consultation, and not with development sitting post application coming to the MOD and saying, actually, I now need more budget. So what would happen, for example, if a development was to come forward and say, right, I'm at number 45 on this list, and I only got 50% of the budget that I need. I need another 50%. But then another developer came forward on the same day and said, I need some additional budget. The MOD, I mean,
is that not what you get though if you haven't got a waiting list, a chronological order waiting list?
The determination is made by the MOD, decision whether to object or not, the calculation of the seismic ground vibration on the straightforward calculation on the day that the application is received by way of intimation. And that fixes. That's the key point which the MOD tends to carry through in its consultation. That fixes the allocation.
But at the point there's nothing to allocate, you have a waiting list. So now it's a point then that this waiting list will just go. There shouldn't even be a waiting list.
The MOD has not operated a waiting list since the judgment of the Inner House in the judicial review.
But between Fosside and that date in 2021, what's going to happen to these schemes in the order that they're in? Like, what's the point of this now then? If you're saying that if they get consent,
so
they don't get any allocation.
Sorry, ma'am, the point of MOD 35 was to provide more information on a list produced by the appellant. This is not the MOD's waiting list. This is more information provided because it thought it would be helpful to provide context on a production by the appellant.
So is the MOD's position then that there is no list after Fosside? So Fosside breached it, and you will look again at allocating whatever headroom there's left once your policy is in place. So all these schemes are kind of in the ether somewhere. Is that the MOD's position? Well,
the MOD can't not look at an application. So as I explained earlier, applications as they come in, the MOD has looked at the chronological order that applications have been received post-Fosside and has considered when the threshold would be exhausted, and that's at Scoop Hill.
And you're saying it's Scoop Hill because it's not determined yet?
That's right.
So on this list, going back to MOD 35, Little Hartfell is consented. 20 Shilling is, we know about 20 Shilling. Chester Hall Farm consented, so it flies off.
Mr. Lawton is on top of the detail here.
Sorry, what's this?
Chester Hall.
Chester Hall. Apologies, I don't know the ins and outs of that one. Can dig them out.
Excuse me, Mike.
Sorry.
Yes.
I just wanted to make a correction of a statement that was made that I don't believe to be correct. In looking at MOD 035, it was suggested that that was our list. This is not our list. This came from the MOD. I have produced a list based on publicly available information, but row number 15, 25, and 29 are developer consultation, which do not appear in any of Zai's list because we weren't aware of that happening. This is an MOD's list.
The list that we put in was appellant document 008.012, and that's titled SDL Meal Consultations Budget Breached. And that was the document that was referred to in the in-house decision and was reinstated. But like I said earlier, it doesn't matter which list you look at. The consented scheme in the Hartfell list is top.
I agree for the list is top. I think what the MOD are saying is that gives it no status whatsoever.
It means it was the next one that we looked at and responded to after foresight.
On a first come, first served basis, which was operating at the time and apparently is still going to continue to operate.
Madam, if I could maybe introduce a hypothetical, because I think it might help illustrate the point. Mr. Milne was referring to the fact that there's a Little Hartfell consented development, and all of this discussion is predicated on that. If we take the hypothesis that it wasn't consented, and this appeal is actually an appeal against the refusal of that application, would the MOD see the appeal from that application as putting Little Hartfell next in line for the foresight budget? Because the case so far seems to be under this agenda item, because it's consented, somehow it falls off the list. So I thought, well, if we introduce the hypothesis that it's never fallen off the list because it was never consented and this is the appeal, would that mean it was next in line? Because I think that will help establish the MOD's position on this.
I mean, that's obviously not the situation that we have in front of us. We have the consented development planning permission granted 3 or 4 years ago, and of course the MOD's position is that that consent's expired. We mustn't forget that there's many threads to this. I'd also have explained the MOD's position in terms of verifying the baseline. Again, the MOD's real fear about simplifying matters and losing sight of the fact that there is a great deal of work to be done to actually confirm if there is any unattributed headroom which is available at the moment to be applied in terms of a published policy by the MOD or for the Scottish ministers to base their development management policy on. So that, as always, that's the sort of necessary long introduction to give But I mean, it is a matter of fact that chronologically, Little Hartfell consented development in terms of receipt by the MOD does fall after Foresight. Immediately after Foresight, that is next.
In loop back to Chester Hall Farm, that application was withdrawn. If that's helpful. Sorry, that's from a while ago.
I was just trying to salvage what else we got off the list, but coming back to Mr. Clark's question, not trying to imply anything, and against the backgrounds you explained, if this was an appeal against the refusal of that consented development, you accept it would be next in line.
James, a live appeal, yes.
The live location.
It's been refused and it was currently effectively, yes.
Yeah, okay. Okay, I'm conscious it's 1:05. Is there anything else anyone wants to add as last comments on that question?
Madam, there was just one point I wanted to pick up. It's quite a narrow one. Mr. Milne, fairly early on in the discussion, sorry, I'm just trying to find it, just so that I get the context completely correct. Sorry, I maybe didn't specifically write it down. Mr. Milne talked about Little Hartfell, the consented development, consented but no allocation, and the suspensive condition. The point I wanted to make was, if we look at the decision notice, we don't see anything about no allocation. And I know we're going to go on and talk about 20 shilling. The only point I would want to make is, if we look at the 20 shilling decision notice, broadly speaking, we see the same. Planning decision notices don't mention allocation of budget. And as we're all aware, the suspensive conditions on Estill for the consented development and 20 shilling are the same, or if they're not completely the same, they're very similar.
I'll come on to look at 20 shilling after lunch. Okay, I'm going to bring this morning's session to an end now. It's 1:08. Is everyone okay if we reconvene at 2 o'clock? Just slightly short of an hour, is that okay? So if we reconvene at 2 o'clock, we'll start with question 9. Again, just put your cameras off, your mics off, and I'll see you back at 2 o'clock. Thank you. Good afternoon, everyone. I make that 2 o'clock. So we will continue where we left off. How we think.
Madam, sorry,
Yep.
sorry to interrupt. In the course of lunch, we've identified something that we suggest it would be useful for Mr. Milne to clarify.
Mhm.
And again, hopefully I've got it noted correctly. According to my notes, and this was under item 4, but that's just for people finding it in their notes. Mr. Milne said Scoop Hill exhausts budget and is before the appeal application. We were going back looking at the MOD 35 document, and we couldn't actually quite figure out how Mr. Milne, the MOD, reached that conclusion. We just thought it would be useful to ask the MOD to clarify the thought process behind that conclusion.
That's fine. That would have been touched on in question 15, but let's just do it now.
Yes, of course. So in terms of MOD 35, Scoop Hill is on row 26, section 36 application. And the present application to appeal is on row 32. And so if you're asking about the predicted seismic ground vibration from Scoop Hill, I would need to ask Dr. Burrs if he has got more to say about that. I don't know
The good
if that's a
news
question.
I wasn't asking that, but so from what you said, the conclusion you reached is on the basis that the current appeal is in row 32, and you're ignoring the application which became this appeal, which is in row 10.
Great.
Where's the application?
Yeah, so the original application, 180188 full, is on row 2. Revised information was submitted on that scheme, which varied the number of turbines from 12 to 9 off the top of my head. And that's shown on row, row 20. No, that's row 10. But this appeal relates to 2001-844, which is on row 32. Is that correct?
Yes. I guess the question put another way, in coming to the view that Scoop Hill exceeds any budget headroom, is that Scoop Hill in isolation exceeds any headroom, or is Scoop Hill cumulatively with everything that goes before it leading to an exceedance of the headroom? Is everything from rows 2 to 26 included in that cumulative assessment? Or is it literally just 26 on its own?
Just looking through my, sorry, bear with me 1 second.
Yeah, well, I can answer that. So it's on its own. We've got 60 turbines within just under 10 kilometers out to about 13 kilometers from the array. And the total ground vibration as a whole for that development is over 1 nanometer, so around 3 times the current threshold.
Mr.
Thank you.
Collar, oh, carry on.
Sorry, I was just saying that answers that question. Thank you.
I guess it does. But if it's just Scoop Hill on its own, then it would breach and come before the appeal. What about all the other things on the list? Have you had regard to those, or are they not had regard to? You just said on its own, Scoop Hill would exhaust the budget.
So it's back to that point, ma'am, that there is a lot of work to be done in terms of calculating cumulative amplitude across the full list. Very much work in progress, which goes to verifying the baseline. It's not just the science. So it was thought to be of assistance in demonstrating the MOD's position that if you just look at Scoop Hill on its own, it takes up the entirety of the threshold.
Okay, that's clear. Thank you. Okay, taking 9 and 10, maybe just simplifying it a little bit in light of the discussion we've had this morning. And it's really just get an understanding that taking phosphide off the list on the basis it's refused, and with all the caveats in place, I'm not trying to allocate budget to anything. If you did add in either the consensus scheme or the appeal scheme, is there sufficient budget without breaching the threshold for either scheme?
Is this a question to ourselves, Ma'am?
It can, whoever wants to answer it first, I'm happy for the appellant to give their view on it.
Okay, thank you very much. So obviously these don't add up linearly, like you can't add one to the other. So you've asked that. So if I just point you to MOD 18 and you scroll to the bottom, you won't get an exam, but I'll just explain it and then I'll give you the full answer is yes, both of them get through. So in how you get there, so if you look at the penultimate line, if you look at Cliff Hope,
yep,
the cumulative figure there, as we've discussed before, is 0.2878698. And then if you look at the site budget allocation for Forside, it's 0.6740235. The way you sum those together, it's called the sum of the squares. So you have to square each of those figures, add them together, and then square root it, and that would give you the figure of 0.7329234 as is shown in the table. So were you to substitute the Forside cumulative allocated budget for those as agreed in the statement of matters, either 0.317874 or 0.16011529, and add them in that manner, i.e. square the first one, square the second one, add them together and square root, both figures would be less than 0.336 nanometers. Would you like exact figures or are you okay?
I'm okay with it just being less than.
Yes, there you go.
On the assumption that someone from the MOD side is happy with those figures, just as a matter of fact, I'm not trying to apply the budget, but just a matter of fact, it would be less than 0.336.
I will ask Dr. Burrows as a view, but of course, I suspect people may be disappointed in me if I didn't say that, of course, the MOD's position is it's premature to be carrying out the exercise like that, because of the many moving parts which need to be settled. Dr. Burrows, is there anything that you'd like to add if it's a question of, I like to call it arithmetic? Maybe not. It's a different.
I think on the arithmetic point, it's indisputable. But that, of course, it's only a prediction from the from the method, from the algorithm, and of course what comes in that list, as we mentioned earlier, is numbers that go into that is a matter for greater exploration over time. I think that's going to be a bit of work.
Okay, that's helpful, and I accept all the caveats around it. Okay, going on to question 11. So if we go on the assumption there is sufficient budget, why can't it be used either for the consented development or in lieu of that, this proposal? Now we've kind of probably touched on that a little bit on this list point, but does the appellant have a legitimate expectation to receive priority for that capacity, which is their position in their appeal documents? And I'll start with the appellant in case you want to add anything to that before we go to the MOD.
I think we'd be probably at danger of repeating what we've said previously in relation to question 8. I think you've got the points already for question 8 that we'd look to make for this question as well.
And just to, I suppose, to amplify from my perspective, the reason you think you've got a legitimate expectation is because you're first on this list. Is that fair?
Yes. Yeah. First on the list. The list has legal status following the inner house decision, and the MOD said itself that well, it's operating a first come first served, and was at the time that Hartfell was submitted, and will be continuing to do so going forward under the new policy. And MOD's also said itself that when 4 sides refuse, then the threshold will not have been reached, and the wind farm developments can come forward with the necessary consent.
Okay. MOD, is there anything you want to add to what you said before? Because we have touched on this in relation to question 8, but maybe in response to that legitimate expectation point from the appellant.
Yes, ma'am, it is as stated just before lunch. That's not how the MOD has operated what has been referred to as the waiting list. And what we have here is the consented development planning permission has been determined and granted subject to a mitigation condition. So the MOD's position is that that consent, the terms of that consent in itself would defeat a legitimate expectation argument, and also, and this is contrary to what the appellant's position is. Of course, you have 2 differing positions. The MOD has not made any express statement or implied that the waiting list in these, that what's referred to as a waiting list in these circumstances would give rise to such a legitimate expectation.
Just can you expand a bit where you said the terms of the consent would defeat a legitimate expectation?
Yes.
What do you mean by that?
So the MOD objected on the basis of there was no budget available, and without reference back to the MOD, Dumfries and Galloway Council granted planning permission, and they granted planning permission subject to a condition which said that the adverse impact of the development on the array would have to be mitigated. As a clear statement of the basis on which that consent was granted.
But would the appellant have a legitimate expectation that that condition could be purified once budget became available?
That's simply not what the condition says. The requirement to mitigate the impact on the array.
Ma'am, if I may, for clarity and to reiterate what we said earlier, mitigation, given the circumstances, would be the allocation of budget.
Which is what we've applied for.
Which is what we've applied for.
Under the condition 32 discharge application.
And of course, the MOD appreciates that there is a pending application, which is not before you, ma'am. There is a application under section 42 to discharge that condition on the basis that mitigation is no longer required, and the MOD has objected. I think that the existence of that application does put things in sharp focus, and I would say supports the MOD's position that that consent was granted on the basis of, in effect, a sort of net zero impact on the array. Put it another way, 0 nanometers.
Alan, have any comments back on that?
Mitigation.
I think, Madam, we're happy to move on.
Okay. Okay, so the next question, question 12. I suppose I have to turn this around slightly. I suppose the MOD still take a first come first served approach. Let's change the wording slightly. Could I, as make a recommendation based on the list, and take the view that the consent to development is next, and that if there's any headroom, they're entitled to be allocated some of that headroom?
Shall I
Pat?
respond? Is that for the MOD to
Yeah.
respond first, or?
Yes, MOD first.
Thank you, Madam. So, of course, the determining authority here in terms of this appeal is the Scottish ministers. Whether that can be disputed. However, the MOD has sought to explain why it adopts the approach that it does and why it does not consider the appeal application to be sitting next in line seeking allocation of budget. And really the most appropriate thing for me to say is that the MOD's position is that for Scottish ministers to step in and take a different approach, contrary to the MOD's view, would threaten the safeguarding of the array. But it would be a different approach. I hear the appellant's position and their position on legitimate expectation, and I've of course noted that very carefully, but the MOD's position is that what's being suggested here by the appellant would involve an innovation on the MOD's safeguarding approach.
Why is that an innovation?
And that's back to the pre-lunch conversation about how the waiting list is not a waiting list to take budget which becomes available, and we have a planning application here which was determined 3 or 4 years ago, which may or may not have expired depending on the view that Scottish ministers take, and it was granted subject to a suspensive condition which dealt with mitigation of impacts on the array, which I characterised a few minutes ago as 0 nanometers, which is not what's being proposed now. What's being proposed now is a retrospective allocation of budget.
If I may, just to perhaps just reminding, I know we're coming on to it, but if we're characterising mitigation as 0 nanometers, we'd just remind everyone that 20 shilling suspensive condition was also mitigation, and is the same approach we're proposing here.
We'll come on to 20 shilling. From the appellant's perspective, do you think I can take a different approach to the MOD?
Madam, yes, and that is the crux of the appeal. And Mr. Milne talked about an innovation in the MOD safeguarding approach. I think from the appellant, and he said the appellant's approach is proposing that innovation. And if I could perhaps put that differently, it's not the appellant's approach, it's the existence of the planning permission. And it's quite clear from the discussion just before lunch, and without wanting to go back over old ground, but it's the existence of that planning permission that is making it very difficult for the MOD to figure out how to respond to the various questions you were asking. You know, much of that discussion illustrates the point that there are valid reasons why yourself, in reporting to the ministers and the ministers in making the decision, should take a different approach. And I would refer you back to, I think it was the appeal submission. I think though I've got a reference that I can maybe get to. Sorry, no, I can't remember exactly what it was, but it was making the point that in terms of the planning process, the MOD are a statutory consultee, and it is for the planning decision maker to make up their own mind, taking into account the views of all the parties. But in law, the MOD's position, the MOD in effect do not have a veto. And again, as we touched on before lunch, obviously the MOD wouldn't agree, but there's some aspects that could be characterised as the MOD wanting to be consistent, meaning they continue to do the wrong thing for the sake of being consistent, rather than acknowledging there is a different way of doing it, and they should do it that way. So the appellant's position is that on the basis of the evidence, the ministers should reach a decision contrary to the MOD submissions, and that would necessarily involve taking a different approach, because it's quite clear the MOD submissions are predicated on their particular approach to the area in the budget.
Okay, I did note in the appeal submission he did speak about the statutory consultee point, and it is up for the decision maker, so I can find that reference. I think before we touch this again, we got into 2020, so we'll move on from this question. Question 13 came about in light of paragraph 9.1 in the statement of agreed matters, and it's a discussion on the up-to-date position on the high technical analysis work. And so is it that better for Dr. Buckingham to start this point, this discussion?
I'm happy to do so, ma'am, if you wish. As you'll see from 0.004.003, which is a series of studies that were conducted on behalf of the Scottish Government, the industry, with input from the MOD. So they were submitted from 2020 through to 2022. And as I explained earlier, this is a move from the worst case algorithm to a turbine specific approach. So this has all been submitted to the MOD and was reviewed by Dr. Bowers back in 2022. And it's there's two things going on. So one is the technical maths and review, and then there's obviously the queue and the implications of that. We did an audit, as we best saw as I, from publicly available information, and we ordered them through that work in order of planning application. Initially, we did it in the MOD's current list, and then we did it for planning application date as an illustrative way of potentially how this would go forward, but we've stepped away from that. So it's now with having been reviewed by industry and Scottish Government, we're waiting on the MOD's final review of both the technical and the process to take this forward. Is that clear? Is that clear?
Yes, it is.
Thank you.
So for MOD, Dr. Bowers, do you want to just outline your position on it, where you're at with this?
Yes, ma'am. And I think, you know, it should be noted the considerable work done by Sci Engineering on behalf of Scottish Government and the SWM Working Group. And it is with me to review refined phase 4 report, which is MOD 024. And on that, as I guess I touched on earlier, I think it does a reasonably good job of characterizing, modeling the ground vibration, seismic ground vibration from constructed wind farm turbines in the consultation zone. There are a couple of questions I have over actually exactly reproducing their results, but I think anticipating a question on timescales, this is probably in the order of weeks and months to resolve those differences. But my concern, and so I think more consideration by the experts, is this limitation that these model predictions are for hub heights around 80 meters, and the building of much larger wind farms in the future is, of course, what's going to happen as the smaller wind farms are no longer manufactured. So that's the concern moving forward. It's not insurmountable, I would assume, but it could take months, if not longer. And I guess in parallel with that is then actually determining what the input parameters of the calculations are, which colleague Mr. Littlejohn touched on earlier, how difficult that is. And then a part really is to try to think the piece forward on this is to help future-proof it. And that you know, we're dealing with turbines which are of hub heights much greater than 100 meters, and motor diameters are much greater than 120 meters. So those are things which to consider. So with that, I think that's where we would see it. So good work so far. We're making progress, but it's not there yet.
And is it fair to say that I think Mr. Milne said that there's a draft policy being considered by the MOD, but I'm assuming you can't or won't finalise that, maybe I'm wrong, until this technical work has been completed and you're happy with it. Is that right? So the technical work has to be done before the policy is in place? Is that fair?
A very fair question, ma'am. And probably the best way to explain this is the MOD does appreciate the desire on their part as well to go out to consultation on a safeguarding approach. So that is not going to be held back any longer by the work that Dr. Bowers has just been talking about. That does mean that the proposed policy will anticipate a further refinement to that policy in due course when the Scottish ministers have put their development management policy in place. To put it another way, the MOD is going to consult on first come, first served and how that works, but is not going to say this is how we, the MOD, will work once the Scottish ministers have brought their proposed seismic impact limit in. It would be too early to do that. So I suppose what I'm saying is there will be a phased approach. The Scottish Minister's policy, I think again it's very important, having been listening to what Dr. Bowers had to say about the current state of the science. It's important to understand that science to be given effect to will require policy decisions and will require a policy in place. Scottish Minister's policy. So when I talk about there being many moving parts, it encompasses all of this work as well.
So I'm just going to try and get the order right. MOD would consult on the first come first served policy to industry. So at the same time, we're around about that. Scottish Government are going to look at their own policy, development management policy, but that needs the science to inform the development management policy. So if it goes out to consult, I don't know what it'll do. It could consult in stages, some kind of idea about policy, get the science, and then consult on a final policy. I don't know how it'll do that, but it needs the science. And then once the Scottish Government development management policies in place, the MOD will put their policy in place.
The MOD will put its first come first served policy in place as soon as it can, and that would, in all likelihood, would be in advance of the Scottish Minister's policy. And that's because of the desire on the part of everyone for a formal published policy from the MOD to be put in place. The MOD is mindful of the fact that its sole interest is the safeguarding of the array, and its responsibility is its policy remit is not to maximise renewable energy generation in the consultations, albeit that's clearly something it supports as part of the UK government. The two policies will need to dovetail. And I do need to be careful what I clearly I'm not speaking on behalf of the Scottish ministers. No. As I've said before, I'm just saying what the MOD's understanding is of the Scottish minister's position just now.
I possibly for a point of clarification. Sorry, Douglas.
Yes.
Thank you. So obviously the MOD have their work to do. The Scottish Government policy work is running in parallel with the technical work. As was said before, we've been working on this for quite some time, Dr. Bowell, since back in 2005 and ourselves since 2010. And we're at the stage where this is a refinement of the technical work. So we're confident, government and the industry is sufficiently confident to run these two in parallel, which is what's happening currently. Thank you.
I did note that, I think it was MOD 10, page 2, which is the notes of the working group. It does note there the Scottish Government is confident that the findings for phase 4 are scientifically sound. So it did sound from that document like they did have quite a lot of confidence in the science to date.
Thank you.
And Dr. Bowers' position is actually could potentially be a number of months. Don't let me put words in your mouth, but of work actually before that science can be accepted. Now it's for Scottish ministers absolutely to determine when they wish to go out to consultation. They can caveat any consultation as they think appropriate. That's entirely for them to do. But the MOD's position, as Dr. Bowers has explained, is the science isn't quite there yet to support a new policy coming in. But everybody is working together to achieve a resolution on that.
So what's the status of MOD 24 and 25? Which is the refined phase 4 report and refined phase 5 report.
So I can speak to MOD 24. I leave it to colleagues speak to what the actual input parameters are. So I guess almost to restate, maybe if I can help clarify. So what the design report in MOD 24 does is model very precisely the ground vibration from a series of turbines, 7 turbine types, of which only 5 are now currently available manufacturers, and which is good. So that gives us a good handle on what has been constructed in the consultation zone. Now, one of the interesting findings, and where I guess we were referring to substantial refinement, is that from going from the original phase 4 reports through to this refined report in MOD 24, there have been substantial extra model parameters that have been added, which relate to structural resonance rather than past models. Now, there's considerable evidence, and I really would appreciate time over the next few weeks, months, available to consult with size experts on this. But it is this structural tower resonance which is related not only to the turbine type, probably the foundations, but also to the hub height and the length of the tower. And we are moving from measuring constructed turbines where the hub height is around 16 to 80 meters, and having to extrapolate much larger turbines that have been consented. So that's the part where so now we've got the constructed turbines in the list, for want of a better word, and we've got the consented turbines on the list, and we're extrapolating a little bit to predict the ground vibration. That part, I think, is tractable, as I say, over a few months. A bit we haven't thought about, I would say. We probably shouldn't be doing research, but is what happens once we've established the baseline. So I think to establish the baseline, for the Scottish Government to make a judgment on what the seismic impact limit is tractable. It's what happens then going forward. And of course, for the policy to sort of get going, if you like, wherever those policy streams land, we will need all of those pieces in place, I would argue.
MOD 24 is kind of like a work in progress.
So I guess it's always work in progress. Yes, it has been argued, I think, that scientific method doesn't work for every question you answer, or that's in the art of motorcycle maintenance. Just to digress, bit of bedtime reading. But yes, of course, and of course, in the end, there will have to be a place where all of this lands, and we have the policy. It'll never be perfect. I accept that. So perfection is the enemy of the good. But yeah, at some point it will have to land. But if there is time while policy guidance is being developed, then we'll take that opportunity to work some more on the phase 4 work.
Could I add one extra explanation?
Yeah.
MOD 24 is the most recent version of phase 4, following the feedback from Dr. Bowers. Thank you very much. And document 004.003 is the previous, actually includes the previous version, which was submitted back in February 2022. So based on the report submitted in 2022, we received MOD feedback, revised it, and that's the most current version in publication.
Okay.
Thank you.
And so MOD 25, which is phase 5, is that the kind of most recent phase 5 report? The same kind of way?
Yes, correct.
Yeah. And I suppose on behalf of Zai, do you think the additional work will take months to complete? I know it depends on the feedback you're getting from MOD and how long is a piece of string, but is it in the realms of months to do the remaining work?
I'd be in an agreement with Dr. Bowers that this is a matter of days, if not months, subject to us getting sufficient time on it.
Okay. Has the working group seen the latest drafts, or latest version, sorry, of the phase 4 and phase 5?
Yes, they've been circulated both to the SWR working group and the wider industry, as they were funded by the Aviation Investment Fund Company Limited and Scottish Renewables. So the industry as a whole has seen these documents. They're actually hosted on the Scottish Renewables website at present, along with all the others.
Okay, okay. Okay, okay. Moving on. Given where you are with the work, the fact that government has got a certain level of confidence on the phase 4 findings, why are we proceeding on the basis of the work to date, introduce a material risk for the safeguarding of the array?
And not from the MOD's perspective, that's because that work should be completed. The points raised by Dr. Bowers need to be addressed and answered in order to inform the Scottish Minister's policy. And given the importance of the array, the MOD's position is that to have a degree of confidence is not sufficient to form the basis for a revised safeguarding approach. Really, I do defer to what Dr. Bowers just explained about the work that still has to be done in order, in particular, that this technical analysis can be applied to the higher, taller turbines. It must also be borne in mind that what the design technical analysis is heading towards, and really where phase 5 comes in, is to inform Scottish Minister's policy on the introduction of a seismic impact limit. And the policy decisions are integral to the safe operation of that system from the MOD's perspective. And of course, by safe, I mean ensuring that the SDMR threshold of 0.336 nanometers is not reached.
Do you have to add to that question?
I don't believe I do on that one specifically. I don't know. Well, the only point I would say is that I believe the appellant is happy to pre-measure, as part of a condition that's been offered up. So whilst we're discussing here how the predictive tool would work, and inherently there will be some leeway in that, having empirical evidence of the explicit turbine prior to installation would see that risk removed.
I think as well, ma'am, I would just remind everyone of the distinction between our primary and secondary cases, and everything we've just been discussing, and to the wording of this question and the previous question, relates more specifically to our secondary case, which is that all the evidence before us is that there is a very real prospect of sufficient budget coming forward for the proposed development looked at in isolation. But I would stress again our primary case, which is that everything we've been discussing in the last two questions and the very promising emerging science and policy is I hesitate to say not relevant to, but we're not reliant on it coming forward and being successful in terms of our primary case, and which is that the consented development should have budget allocated to it according to the policy that was in place at the time, and that we can work within that. So it's just to remind everyone of the distinction between our cases.
That's a fair point. I think on the back of that, I'm going to jump to question 17 and 18, which is about 20 shilling. Because I think it's appropriate to think about differences or similarities between your primary case, and the 20 shilling proposal. And it seems to me just that there are similarities between the two. I just wondered if they have both been treated the same, or if the MOD has been inconsistent in how they're treating this case and the 20 shilling case. So I'll start with the MOD first. And there's a bit in the statement of agreed matters where it sets out the background to it. So my understanding is that it was originally consulted on in 2013, June 2013, and that was for 9 turbines, 27 megawatts capacity. Then there was a section 42 application that came in. And that would have been after the consented development was consulted on. So yeah, it was a section 42 application to change the height of the turbines, and that was then granted permission, subject to a suspensive condition. And the statement of agreed matters notes the terms of suspensive condition down there. And then, as a result of a legal agreement and mitigation, that condition was then satisfied. So it's similar in the way that I suppose there's an original application, consent was granted, MOD objected to the second application, and permission was granted subject to suspensive conditions. That all seems fairly similar between the two proposals, albeit one was a section 42 and one's a new application. Suspensive condition, I think we said previously, is very similar in both cases, maybe not identical, but very similar. So I guess, how did the MOD get to the point where they were happy for the condition to be satisfied, in light of the fact that the budget had been, or the threshold had been breached by Fosside?
So they appear similar, but the difference, which is the answer to your question, is that the 20 shilling application to which the section 42 application related had been allocated budget.
And is that because it'd been allocated budget in 2013?
Yes. Pre-Fosside exhausting the budget.
So if it'd been allocated budget, why did the MOD object to section 42?
So it objected to the section 42 application because that came in after Fosside, so it was treated as a new application, because of course the MOD doesn't look at developments, it looks at applications which come in before it. It's consulted on the applications. It looked at the seismic ground vibration, the predicted seismic ground vibration, which the amended application would require, and rejected on the basis that there was no seismic ground vibration available.
The maximum tip height went up 25 meters, so the difference in dimensions generated more seismic ground vibration. So it's a case of it would have greater impact and therefore wasn't acceptable because there's no more budget to draw from. Foresight effectively occupied the remaining.
Okay, I see what you're saying. And how did the MOD get to the point that they were satisfied the condition could be purified?
So the MOD, of course, objected, and it was in face of the objection that the condition was attached by the local authority, and then understand that the developer came forward and put forward a proposal very like. This is a similarity with Little Hartfell came forward and suggested testing of turbines in field in order to measure what the seismic ground vibration would actually be, and entered into an agreement which in effect provided that that is what must happen. The new planning permission arising out of the Section 42 application and development must operate within the seismic ground vibration which was allocated at the time the budget was available, which was allocated to the original consent to which Section 42.
Okay, does the appellant want to comment on this?
Yeah, just a couple of points of clarification. I think you're there, so you'd like me. So using MOD 018 and MOD 035, it's easiest to find it by date, but halfway up the original 20 shilling of 3rd of June 2013 is in there, and you can see the allocated budget, which is 0.002014, I think. It's quite hard to see on my screen. So that was the original 20 shilling. Then if we look at MOD 035, so number 3 on the list there is a 20 shilling hill. So the similarity being their initial application was for smaller turbines and they wanted larger turbines. So they proposed and had an agreement with the MOD that said that original budget allocation from MOD 018 wouldn't be exceeded, and this would be evidenced through measurement. So this is in fact a moving from the worst case algorithm to an empirical measured turbine, and that there was a legal agreement put in place which allowed the proof that this site on number 3, if you use the worst case algorithm, it would obviously exceed the budget, but they measured the turbine to show proof to the MOD that there wasn't a risk to the array and that it could work within its seismic budget, the 0.201. So that was a mitigation agreement between the MOD and that organisation, which wasn't a mitigation of 0, but a mitigation of we will work within a specific vibration budget through evidencing the turbine that will be put in place. Thank you.
And the key difference being here is that the MOD's view is that the consented development doesn't have any budget allocated to it. Therefore, there's nothing you can compare this one to know that it's acceptable.
That's right.
But if ministers were satisfied that I suppose, in the appellant's primary case, in that the consented development would be next in line, and that this scheme could be operated within that scheme's seismic budget, perhaps subject to condition that they would test the turbines in the field. That would therefore be very similar to the 20 shilling scenario.
If Hartfell had the budget, then it would be, you could draw that analogy, yes.
And then just as a clarification, Mom, sorry, 20 Shilling Hill has actually been built. It's an operational site within the array. And subsequent sites on MOD 035 lower in the list are also operational.
Yeah, I know, for example, like Cross Dykes is operational.
Yes, that's correct. They did a
further
similar
down the
thing
list.
in, yeah, so they also changed the size of the turbines and required evidence for the MOD to allow that to be constructed.
Okay, so part of the crux of this then is the list, the status of the list, what the list means. Is it on the list? Which would be something for ministers to consider. Okay. And we've got anything else you want to add in relation to 20 shilling?
Oh, thank you.
No. Okay. Right. Question 19. And this is about, and I think we may have covered this, but maybe a couple of follow-up questions. Given the uncertainty, no further applications for wind turbine development in the consultation zone should be permitted until that uncertainty is resolved. So I think from today, it's the uncertainty around, well, my understanding is the actual threshold won't change. It'll still be 0.336. It's uncertainty about threshold. There's uncertainty about the impact of taller turbines, and I suppose certainty and accuracy around extrapolation as opposed to measurement. And then it's uncertainty as to how that headroom, whatever that headroom might be allocated or used within that the consultation zone. And I guess there's, from looking at the documents, there's different ways that, or different parts of policy that could be applied. You could extend the exclusion zone. You've got the background noise issue. You've got the safety, things like that, which could all impact, I suppose, on the science, the engineering, plus the policy. So are those the kind of, does that encapsulate the uncertainties that the MOD face at this point in time?
That plus the verification of the baseline, so as the MOD is clear as to how much seismic ground vibration has been attributed to already consented developments. And that's transpiring to be a piece of work of considerable complexity.
Yeah.
There is an element of, should certain applications be removed, is it appropriate to do that pre-consultation? There's an issue regarding have the key parameters to apply the 2014 algorithm been appropriately captured in consents which have been granted, or is there a risk of those as-built parameters changing in a way which increases the predicted seismic ground vibration, which is a planning issue? So there are lots of issues being considered just now, because now is a good time to revisit what has been work in progress over 20 years to get to a point of what is appropriate today. All of those factors plus the ones you listed now.
Now, I think we've got all those uncertainties in the background, and it could take, I suppose, months, maybe over a year, to get to the point where there's certainty. And I think the MOD's position in MOD 029, with the response to Callister Hill, was that it would object to all wind farms which would cause the threshold to be exceeded, applying the current SLMUR SGV predictive model. So I just wonder if, in this case, the budget wouldn't be exceeded. So is that balance as a decision maker and for Scottish ministers is, do you just put everything on hold while there's all these uncertainties with the timeline, or do you look at this objectively and say, well, actually, the threshold will not be exceeded, therefore permission should be granted?
Could I add a point to that, Mom?
If you can.
Thank you. I think we covered this earlier on when we were calculating what if the statement of agreed matters, the two values, were added to the queue using the existing system, which is this worst case system, which was designed to be intentionally conservative, and there would be sufficient budget, as you rightly say, with either of those calculations. So yes, there has been a lot of work ongoing. We are at an advanced stage such that the Scottish Government and the industry have confidence. Inevitably, there are some small refinements to be done, but this case doesn't rely on moving to that system. You can still use the old system to do the calculations.
Taking that on board, the MOD relies upon in maintaining its objection here to this development, to this present application, that no budget has been allocated to the consented development, and if that position were to change, that budget would need to come from somewhere else.
But I guess the budget's not been allocated anywhere.
What
In your, if we're saying, because there's a discussion about budget isn't really allocated, it's just kind of a thing that's there.
the language issue.
Yeah, I know we use allocation, but it's not. If the list isn't really a list, and we know there is budget there, why can't this application get that budget?
I mean, in this appeal, we have one developer saying that they have a legitimate expectation to what becomes available following the refusal of another application. I think it's fair to say that if the MOD were unilaterally to change the approach, which I have explained it takes, other developers would say, but we had a legitimate expectation to budget in respect of our developments. This is why the MOD is exercising such care, attempting to exercise such care around its position in response to applications and informing how they are determined as a statutory consultation.
So even in this situation where the appellant can point to a waiting list, consented development being first on that list, disregard putting to one side the status of the list or what the list might be, you don't think there's different circumstances or unique circumstances in this case which would avoid a precedent being set?
Absolutely not. I don't think there are unique circumstances. The MOD's position would be that if the suspensive condition, which referred to mitigation for the consented development, were to be treated instead as a holding point for any headroom becoming available, then that is what other developers would seek. And that would take the allocation of budget from the position of on consultation or on validation and put it at the end. So I put beyond the end because it would be post-consent when a developer is able to say, oh, something's been refused, I should get that next. Based on however they would calculate it, I'm not entirely sure. It's to upend the MOD's approach, and that's their fundamental concern. And if it's agreed to, MOD's not the decision maker here. We Scottish ministers, we know that. But if the MOD were to change its consultation approach, its safeguarding approach, in this case, that would absolutely be relied upon by other developers in other cases. And I'm sure we'll get to what the implications could be for the Scottish Minister's proposed policy consultation in terms of how it's anticipated that they will want to safeguard maximising generation within the consultations ongoing forward.
What do you do now that Forsyth's been refused and there is headroom?
So the MOD's position is that there is a chronological list of applications which have come in post Forsyth. That's mod 35. And the MOD's position is that given the applications which are sitting there in chronological order as they are, when you get to Scoop Hill, you can say that actually no budget will be left. That will exhaust the budget. So the MOD is objecting to everything which is coming in.
Everything after Scoop Hill.
Well, because of how things have worked through, the MOD has been objecting to everything since Forsyth.
Mr. Milne, at the top of the chronological list you refer to, what's at the top?
So, sorry?
What's at the top of the chronological list?
Forsyth? Mod 35 Forsyth.
Your pardon, yes.
Okay, we've got Forsyth and we've got Little Hartfell, but your position would be that's now not beyond that list because it's a planning permission.
Sorry, I didn't hear a follow-up question. Sorry if anyone was expecting anything from me. So the list starts with Forsyth, which has been removed. Little Hartfell, I mean, there's a list of applications which have been received, and when the MOD updates its list in light of all of the work which I've been explaining, Little Hartfell would be next. As a determined application with presumably zero allocation because it has a mitigation condition. And then next would be 20 Shilling Hill. I'm preempting the policy consultation here, as I said I wouldn't do, but that's what's proposed and how the MOD is considering matters at the moment because it can't just refuse to respond to consultation requests.
But the Scottish Government has said that the consented projects won't be captured by future policy.
And I don't understand the relevance of that.
Little Hartfell is consented, so it won't be subject to any new policy on how you allocate budget. It'd be subject to the prevailing allocation policy in place at the time.
And it has a zero, the MOD's position has a zero allocation. It is the decision that was taken. That was the decision.
Sorry, Mum, you're on mute.
Sorry, I will mute, yes. I see that's the crux of it, and that's the distinction between an MOD list and a planning determination, and whether the two are interlinked to crossover or should be viewed separately.
The MOD position appears to be, in the interests of safeguarding, we will not allocate budget to a consented project now that it is available.
The MOD's position is it's never done.
No, that would be a departure from what we've done before.
When you say you've never done it, is that because you've not been in this position before?
I'm not aware of ever having been in that position before. No.
Doesn't that on the face of it suggest that there are unique circumstances here?
There's not. No, there's been an application. We've responded to that application with an objection. It has gained a consent despite our objection. It has no budget allocation. That's the position we're in.
You've just said you've not been in this situation before. Is that because there's not been a situation where a permission has been granted and headrooms become available, as it has in this case because false size has been refused?
To the best of my knowledge, we've not been in a position where an application scheme such as Foresight has occupied all the remaining headroom and then been removed from, or potentially been removed from that.
And so the next application on the list that will exhaust things is Scoop Hill. I appreciate, ma'am, that it's just, there's a clear, I suppose there's development in the MOD repeating the respective positions isn't going to meet them.
It doesn't change the position, no, but it makes positions very clear in my mind what the crux of the matter is. So it's, from my mind, I'm very clear now what the real crux of the issue is. Because I need to report this to ministers and set it out, so if they either disagree or agree with my findings and recommendations, they can either go along with me or they do something differently, but they need to have enough there so they can do either or. So that's why it's important to understand completely the crux of the argument and where the key points are that can go either way for them to make a decision on it. So it is helpful. I know it's a repetition, but it is helpful because now I'm very, very clear in my mind the key points of how you get to a recommendation, the things that you need to think about. So yeah, don't apologise for the repetition, it's absolutely fine. I thought that might be the case once we started going through it, so it's fine, and I am kind of adapting things as we go through. Is there any other comments just on that point about, I mean, I'm just saying that there's not been this position before, and I think there hasn't been the situation before where something has been refused which suddenly frees up a lot of headroom and you've got developments that have been consented.
The closest we got to that, ma'am, you referred earlier to the interim guidelines, where I'm looking at Dr. Bowers for inspiration. 2014, the updated algorithm being brought in, the interim guidelines were published saying that everything, it is helpful to mention, everything which had been sitting, and I really hesitate to use the word queue, but everything which had been sitting blocked because a particular wind farm had exhausted the budget. When the SWR working group sort of concluded its work and MOD and other parties were content that they had reached a position of certainty, that allowed the MOD to withdraw its objections to the pending applications. And without looking at the interim guidelines, I think it acknowledges that that's what would have happened. So there's no reference in there to what I am referring to as retrospective allocation to consented developments. What happened was that budget was released to pending applications to allow the MOD to withdraw its objections.
Could I add a point to that, Ma'am?
Yes.
So we are going back into history here, and I'm also trying to remember. But the work we did between 2012 and 2014, effectively there was I'm sorry, Douglas, using the word queue, which was based on the point at which they contacted the MOD, very similar to that one being MOD 035. So there was actually pending development for over 1 gigawatt of wind farms within that region. So that sat in this queue until, as Douglas said, we got the revised algorithm, which then gave them the certainty. And so that queue then subsequently, the objections were removed. I think the point here, and I can't tell you exactly, I'm not a planning lawyer, was whether or not any of those actually received planning prior to that objection being lifted. But that's a point in the past when the budget has been full, there's been some technical work which has freed up, or there's been an event in which more budget is available, and then it just followed through based on the date or chronological order in which they'd contacted the MOD.
Okay, yeah. It does say in the guidance that, yeah, objections were withdrawn and the MOD's going to use best endeavours to withdraw objections which have come forward since December 2013.
Yes, ma'am. So those applications were just sitting there, and that's the difference. We can draw a comparison there between 2014 and where we are now, because those applications had been just sitting, no doubt for a variety of timescales, because of the MOD's objections. The various consenting authorities presumably were content just to leave them there, but then the budget became available not because of the refusal of anything, but because of a new approach, a better, more advanced approach to the prediction of seismic ground vibration, and the MOD withdrew objections.
Are we really saying then at that time, if one of those projects had been approved subject to a suspensive condition on Estelle Muir, that project would have dropped out of the system and the applicant would have had to reapply for a new scheme to reconsult with the MOD to get a budget allocation? Is that what we're saying?
Sorry, if that's directed at me, if planning permission is granted in accordance with a condition, the legislation informs us that that's to be for the purpose of regulating that development in accordance with the condition. If it was a planning permission which required mitigation, that would have been the decision, and that's the condition which had to be applied with. That's what the MOD's case is here.
Okay, just look at the interim guidance. There is actual advice that planning authorities are advised to delay determining any applications pending the outcome of the consultation. I guess there's been no advice to a similar vein since Fosside breached.
No. No one in this room is aware of any such advice, and is anything based in the working group? No.
Yeah, I'm not aware of seeing anything.
What's happened in the past in a similar but different set of circumstances.
And is there any policy, MOD guidance, government guidance that makes it clear that if your application is granted with a suspensive condition, you drop out of the list?
No. Nothing has been written down and published to that effect. The MOD is relying here on the terms of that consent and the fact that it allocates budget at that very initial stage of consultation.
Okay. We're just having a 10-minute break just now. Till 3:30. Okay, with everyone, right? Again, just put your cameras and your mics off, and we can reconvene at 3:30. Thank you. Okay, welcome back everyone again. Thank you. Does anyone have any comments they want to make to close off what we just discussed, or can we move on to question 20?
Happy to move on.
Happy to move on? Great, both parties have to move on. Okay. Right, I may slightly change the wording. Question 20. My understanding is the budget threshold will stay the same, 0.336. But is it reasonable to assume that the headroom won't decrease as a result of the technical work that's ongoing at present, albeit that needs to be finalised? Is it reasonable to assume that headroom will not decrease?
Can I answer this one, Mom?
Yes, you can, and I'll come to Dr. Bowers. I'm sure he might have something to say on it.
Yeah, thank you. So yes, you're correct. 0.326 remains. So then it's what the headroom is, which currently would be what's left post. Now that Foresight has been, or assuming Foresight does fall out, so the 0.287. So the threshold being the difference between that, the headroom being the difference between that and the 0.336. So I believe it will decrease. The overall budget amount or headroom will increase for two reasons. One, the MOD 018 list needs to be updated in terms of the sites that no longer have either been rejected or have got no prospect of obtaining planning. And then the move, as we've said, from this worst case algorithm, which was intentionally conservative as we had very little data at that point, to an empirical turbine basis. And that, based on the evidence of the phase 4, phase 5, is all showing there will be an increase in the headroom available in making that move from intentionally conservative algorithm to measured data.
Dr. Bowers, do you want to comment on that?
So I think that statement is reasonable if the list of input parameters in the phase 5 report, or the updated phase 5 report, is accepted. But I guess that's what MOD are questioning, and I guess I'd hand over to my colleagues to comment on the work that's required to get that audited list up to some sort of sense of completion, and I guess probably the timelines would be helpful.
Is that inputting turbine heights, all that kind of stuff in that phase 5 report, which is I think what Mr. Littlejohn's pulling together. Is that correct?
Yeah, that's exactly right. The audit work that we've been commissioned to do, and which we'll be engaging with JI on going forward, will look at consented developments, including against that which has been constructed on site. So we are picking up a little bit of ambiguity across some of the records available from local authorities against what has been constructed, as you might expect. Clearly, maximum parameters are often provided with planning applications, and that can differ then from ultimately what is constructed on site. There's a bit of ambiguity coming in as well around about developments which are part implemented, for example, and as you suggest, variations across rotor diameters, hub heights that are ultimately built out as well. So there's quite a lot of work to do. I would agree that I think the statements are reasonable, but at this point in time, it's difficult to say with any certainty as to where any ultimate headroom will sit.
And Mark, if I just had to draw that together, that in terms of the safeguarding of the array, the MOD would not be inclined to proceed on the basis of assumptions, but rather to allow the work to have been completed and know what the available headroom, if any, actually is.
Any final comments from the appellant?
Just one, in the Xi have done this, or like understand the complexity and the difficulty in doing this audit. Xi has conducted this audit twice with the input of the Scottish Government and the industry, which is why you have the current MOD, I believe 25, 26 or 24, 25. So it does take a long time to run through the as-built, the dimensions and so on and so forth. It has been conducted twice on behalf of industry, and now the MOD are conducting that same review.
Okay, thanks. That's helpful. Question 21, and I guess from the Pelt's primary case, this is completely irrelevant, I would say. Looking at their secondary case, it seems to be that, I suppose, how the noise budget will be allocated, there's this uncertainty around that. Looks like a SIL would be the most likely option. And there's a comment made by the MOD in relation to that, which was that the scheme would require significant engineering mitigation to meet the SIL. And I just wondered on what basis that was said. I think it was in your hearing statement.
Yes, it is.
Hello.
Dr. Bowers will be able to assist with that. 3.62. Oh yeah, that section. 3.62 and 3.63 of the MOD hearing statement. Dr. Bowers prepared to explain his understanding of the implications of allocating any of the budget to the consent development. So 3.63 of August.
It was a point actually 3.62, which was the proposed development of Hartfell would require significant engineering mitigation in order to meet the SIL proposed by Xi Engineering Consultants Limited's technical analysis.
Okay. I won't be Marv, she's catching up.
It's okay.
My afternoon cup of tea hasn't. So I think I need to go to MOD 020. Yeah. So, and table 8, which is on page 18. This is a Xi report. Quick list of all. So currently, the Storming Working Group and Scottish Government considering a seismic impact limit based on the estimated headroom and a minimum electricity generating capacity of 2.5 gigawatts. That's what this table is based on. It's based on the original phase 4 results, not the refined results, which I can comment on as far as I can. So you'll see that little Hartfell spelled incorrectly, but assume it's the same development. Yeah. Number 113, and you'll see that there's the far right hand column has SIL requirement, and that's showing 34.9%. So the meaning of this is that to meet the seismic impact limit, you would have to reduce the predicted seismic ground vibration to 34.9% of the predicted. So that's a considerable amount. Now, when I rework those numbers with refined phase 4 for the wind turbine types, which I can actually get very, very close to the Xi calculation. I'm sure it can resolve the other remaining differences. Essentially, that number goes down to 25% for the closest turbine in the Hartfell proposed development. So what would need to happen there is that some kind of technical mitigation, some engineering mitigation, need to reduce the vibration to 25% of that predicted. Now,
when you're doing that comparison of looking at the SIL requirement for the development, just to be clear, is that based on the standard EKA SGVs, or is it got Nordex as the turbine, or is that based on the Nordex? So it has been measured already and you're doing that comparison, or is it based on the agreed SGVs we spoke about earlier?
Okay, good question. So this is based in this table 8. It is based on the predicted seismic ground vibration for the Nordex turbine as modelled in the original phase 4 study by Xi. So I can update those numbers for the refined phase 4 and the turbine types. I have models that are very close to the Xi numbers of the Siemens, the Nordex, and for the Vesta. And if I take the Vesta, is kind of the worst of those 3. Then it's the closest turbine would need to be effectively, vibration would need to be reduced to a quarter of that predicted by some kind of technical mitigation.
Okay, that just puts that your comment there about significant engineering into context, which is helpful.
So there is, my understanding, Xi, I guess Dr. Buckingham's best place to comment on this, but I understand there is a project, if not started, in the offing to try to estimate what sort of some we might call conventional engineering techniques that are used for earthquake proofing buildings, or reducing resonance structures. There's also some kind of active control. Those techniques are out there to try to see what the scope of such techniques might be for reducing the ground vibration from wind turbines. But I understand that's a research project, and I think at that point I can come back to the 10% value later, because that's in a different context.
Okay, Dr. Buckingham, do you want to comment at all?
Yes, please. Again, just to clarify on your initial point, so obviously we've got the headroom, which then gives you a certain amount of nanometers to deal with. And one of the things the Scottish Government are very keen on is to understand how to optimise the amount of gigawatts from the region, which is the work for phase 5 that is trying to look at a bit of a crystal ball and go, where do you put turbines and how might it be impacted? But the premise of all of this, and as we know, if turbines closer in have a disproportionately effect to the list, so it's what can be put in place in order to ensure that those coming closer are not as disproportionate. And this is what's been proposed as the SIL, or seismic impact limit. If you think of it acoustically, if you've got a sensitive receptor, usually a person, and you want to put a wind turbine relatively close, you would use a quiet turbine. The receptor in this case is the array. So if you want to put a turbine quite close, you should use a quiet turbine. And as with acoustic turbines, there are now mitigations that can take a standard turbine and actually physically reduce the acoustic output. So there is a proposed piece of work in front of the AFCL and Scottish Government to actually determine what the likely range of reduction would be possible using technologies that are standard in other industries, such as a seismic isolation or control measures. So Dr. Bowers is correct in that. The level of the SIL is still to be determined. The report that's referenced, table 7, is the prior table, is the least. So there are there's a range of fills looking at from 1 gigawatt, which would guarantee you a guaranteed 1 gigawatt in the region, to 2.5 gigawatts. And these are different levels to be determined. And the industry obviously wants to optimize a whole region, but not cause issues close in, which is why this body of work or research will be undertaken, where technologies used elsewhere can be implemented to turbines to prove and evidence to the MOD that sill impact limits or very quiet turbines can be manufactured or adjusted.
Okay. And I guess part of that discussion is also looking at the extension of the exclusion zone to 15 kilometres rather than 10, to see whether that maximises gigawatts.
So yeah, the different levers. We were doing analysis of the what ifs in that version of the sort of phase 5. You know, so the industry can look, what if you put the 15 kilometres in, what if you put the 10, and how you treat that going forward. So that's the whole range of different options. Obviously, there's no intention to create policy with any of that. We were applying that actually to the list in chronological order. But yes, that is correct.
Okay, I think I'm clear on that and the MOD's statement about significant engineering mitigation. Just one point just to pick up on actually, when it comes to a new policy from the MOD's perspective, who has to approve that as part of a process? Like it's obviously reviewed internally, so you've gone through your consultation, comes back to MOD reviewed. Does it have to go like to the Comprehensive Nuclear Test Ban Treaty Organisation for approval? Are they involved with this at all? Or is it just purely the MOD that can approve and issue policy?
Just the MOD, ma'am.
So if I could add, I think maybe Steve can speak as the national, Mr. Laws can speak as the national authority, but I think we would keep any decision, keep the people in Vienna and the treaty organisation in the loop. But we wouldn't require approval. We would explain what we're doing. I think that's part of our sort of communication as a responsible state signatory.
Dr. Bowers is correct, Mark.
I guess this speaks to the wider point that it's not just the UK that is struggling with balancing commitments from IMS seismic stations and renewable energy concerns. So it's a thing that's becoming a global issue. Thanks.
Thank you. Moving on to question 22. And maybe we've kind of covered this. It's about, we've touched on the point with whether this would create a precedent, but it's whether this appeal would undermine the SWO working group and prejudice the development of further policy and procedure. And I suppose the MOD, your position would be it would prejudice that because it's a different approach, it's innovative, it's not what you've been doing. There's risk of other developers trying to do the same thing. So I think we've probably covered it, unless there's anything else you want to add.
Yeah, and yes, ma'am, I would, that encapsulates the MOD's position, the desire historically has been and will continue to be to develop policy in conjunction with the SWO working group. But I suppose another aspect to undermining the collaborative approach and prejudicing the development of further policy and procedure is what is in the MOD's hearing statement at 3.63. Now, this inevitably takes us back to this question of whether the Consented Development Planning Permission now has budget or not. So I of course accept that. So 3.63 is a paragraph which is predicated on the MOD's clearly stated position that the consented development planning permission has no allocation. And ma'am, if you find it helpful, Dr. Bowers can put a bit more colour around 3.63 and what the MOD is saying here.
Yeah, ma'am. So I guess speaking really to the last two sentences, paragraph 2.63, I think we dealt with most of these other issues before regarding the sill and engineering mitigation. So at the moment, this sill value, this headroom, is calculated on the basis that Hartfell has not been consented. It's not used in the calculation. If it were to be consented, then on the basis of the predicted ground vibration, then I'm using here the refined phase form SI results for the three turbines that I say match. So I think this again was the Vesta 90, but it doesn't, Vesta 80, but it doesn't make much difference. So you would add in the Hartfell seismic ground vibration, and that would have the effect of reducing the sill seismic impact limit by about 10%. So depending on what basis that was determined, if we assume the 2.5 gigawatts as the minimum generating power, then this has the effect of pushing the closest a wind turbine can be to the array location without any engineering mitigation. So just by choosing the turbine type that we know of, it would increase the area, decrease the area from where mitigation would be. It would increase the area where engineering mitigation would be required by about 150 square kilometers. So the effect of adding more and more, or reducing the headroom by putting more developments on the list, it reduces the headroom, it reduces the seismic impact limit. That would be the policy proposed by structured government, and it would increase the distance, the array where turbines could be built without engineering mitigation. So those are the trade-offs.
Okay. I'll just think that through.
Dr. Bowers, you say that the value of the cells calculated without any reference to the SGV from the Hartfell. Where do you get that?
So those are the calculations in the XI. So those are the assumptions in the phase 5 are recalculated. So that headroom 0.26 nanometers. So that's the effect.
Might I come in to assist on clarification?
Yeah, that would be helpful.
So you need to understand how the sill is calculated. So the seismic impact limit, we take the headroom and then we say, what if we put, so we need a gigawatt being the lower limit of the sill, at what distance would you be able to achieve a minimum of 1 gigawatt within that zone, but for a standard turbine, and that in itself creates a level. So the sill is dependent on the headroom, which is dependent on the queue and the order and the math. So once you get that, you understand the sill. So we've done a couple of variants of phase 4, and because the sill is calculated from the headroom, it negates a change in the sill, because that's just how it's mathematically calculated. So the sill range is currently between 1 and 2.5 gigawatts that we mathematically analysed. And if you change the headroom, you change the sill. In changing the sill has yet to be determined. Industry, I think, is starting to move towards a 2 gigawatt. But again, this is based on the sort of theoretical what you could put out there.
Okay. Okay, was Little Hartfell not included because it wasn't in the queue before Fosside?
In terms of the SIL calculation,
Yeah.
so the SIL calculation work, we basically took MOD 18, then we audited the queue, those ones right at the beginning of today where I said those sites have been removed.
Yeah.
We removed those to work out what the maths was, and from that we then calculated the SIL. We did that with and without specific sites, so we did it randomly putting wind turbines in, and we also did it with Little Hartfell in it with a SIL imposed on it. So we did a number of variants.
Okay. Okay. Dr. Howard, do you want to say anything else?
No, I think that's what we'd say. I guess it speaks to the fact that numerous variations of defining the SIL have been proposed, that there are many moving parts, and I guess we need to land somewhere. We haven't landed there yet.
No, I get that. I get that kind of various, I suppose, yeah. Various options have been modelled.
If I might add, there are lots of options been modelled. You know, the way it's calculated is very matter of fact, take the headroom, calculate that. But if you think of it more as an absolute noise level or a speed limit, you know, the industry has to pick how noisy a wind turbine, and they're going to pick one level, which will have a value, and that's what we will have to work to.
Yeah. Oh, you're right. You're saying you need to start somewhere. You need to have some kind of working assumptions to get to a point. Okay. Question 24. This one's really for the appellant to comment on. It was just the point in your cases that the council has been inconsistent. Obviously, granted the first Little Hartfell, and it's refused this case. Each case had an objection from the Ministry of Defence. I was just wondering if you think, has it been inconsistent, or has it just given different weight to material consideration?
Madam, I think it's neither really. If I can refer you to our appeal statement, which we've numbered APP-1.2, and at paragraph 10.10, what we say there is that the reason given by the council is based on an erroneous interpretation of the MOG's objection to the original application.
Okay, that's because you're saying that they objected unless a solution can be found. So it's not an absolute objection. Again? It's not an absolute objection. It's an objection subject to mitigation or a solution being found.
In the appeal statement, all we've done is interpret the wording from the MOD and suggested, in our view, the interpretation given by the council to that is erroneous.
Okay, and then you say that you don't think there's any change or shift in the material circumstances.
Yes.
That would justify a different decision.
Yes.
In both cases, Fosside was in the queue.
Yes.
Okay. Right, going on to 25 on suspensive conditions. Start with the MOD. Your position is that a suspensive condition is not appropriate in this case. Can we just have a wee discussion around that?
So I suppose the starting point is to ask what this suspensive condition would now be seeking to achieve. If it's a condition which is aimed at taking advantage of an allocation that the consented development planning permission benefits from, then you have the MOD's position on that. There's no, the consented development planning permission has expired. The consented development planning permission has no allocation. So that's not a condition that would really satisfy the tests in the circular. If what the appellant is actually seeking here is mitigation to meet a sill, I don't understand that to be their case. But if that were the case, then the MOD's position is, as Dr. Burrows has explained, that extensive engineering would be required in order to reduce the vibration from the turbines down to 25% of the predicted seismic ground vibration for the turbine closest to the array. And the MOD's position in that respect is that that is a research project. That is a very significant piece of work which would not be appropriate to form the basis of a suspensive condition. That gets quite close, albeit in a different context, to the argument run against the use of a suspensive condition at Foresight. And the MOD's referred in its hearing statement and lodged a more recent Narracon decision. The MOD referred to the Clockery decision about untested and untried mitigation solutions. But hopefully that's clear. It really depends what sort of mitigation we'd be looking at. There seem to be a number of suggestions here.
I'm assuming the 20 shilling suspensive condition, which similar to the one in the consented development, is not acceptable because there's no allocation.
That's correct. And also, please do bear in mind, ma'am, that the 20 shilling condition was not one which was discussed with the MOD or agreed.
No, because she objected to that one.
Yeah. So I wouldn't want it to be thought that the MOD thought that that was an appropriate condition to use if it were being suggested that there was a budget which could allocated budget for the consented development planning permission which could be relied upon here.
Ma'am, just a point on that where a parallel was drawn to Foresight, just to state or as MOD states in its closing submissions, that's app 7.1. It does set out that the granting of 20 shilling and Little Hartfell, they were suspensive conditions in materially different circumstances, MOD's words. So there isn't a parallel with Foresight. It's essentially the same as 20 shilling, which is often cited as an example of good enforcement over a suspensive condition. And it's no different to what we're proposing here to couple it as well with a legal agreement.
Ma'am, you're on mute.
Given the change with Foresight, speaking this for the appellant, is the same condition to the previous consent what the appellant thinks is necessary in this case?
Sorry, Mum, could you repeat the question, please?
Okay, so the proposed conditions from the appellant are seeking a similar condition to what was in the consented development plan and permission. And in light of, I suppose, full sides and everything, particularly, is that condition still suitable? And is that still what the appellant would be requesting?
Well, we're open-minded to working together towards better wording if there is any, and more agreeable wording. We're not precious about the particular wording. We think it is suitable. I guess it brings to the fore the lingering doubt that over Simon's comments earlier, where mitigation is 0 nanometers. I mean, that's a nonsensical mitigation solution. You can't achieve 0 nanometers. It's the same wording as 20 shilling. Wasn't the solution for 20 shilling, which itself is cited as materially different and an example of good enforcement. So
yeah, the intention would be with the condition is that a separate legal agreement would sit behind that with the MOD that would set out a requirement for the appeal scheme to operate within the seismic impact associated with the consented scheme. And there'd be requirements for pre and post monitoring to be done with remedies in place. If we were found post-construction monitoring to be operating outside of that seismic impact limit. So whether the condition could be more precise in that regard, certainly open to that.
And I'm assuming that if four sides out of the picture, four sides refused, a condition would still be necessary to ensure that you're not taking up all the budgets left over. Your budget would be what's associated with the consented developments. That's why a condition would still be necessary. Is that what you're saying?
yeah, we know that the proposed development is not next in line for budget. That is the consented development.
I suppose if looking at it the other way, if the consented development being first in line was up for determination today, there wouldn't be a need for a condition at all. It would just receive no objection from the MOD going through the standard model. There would be that no requirement for a condition, and then subsequently with the future application to increase the tip height, there would be a requirement for a 20 shilling style condition with an accompanying legal agreement, so that we didn't operate outside of the seismic impact associated with the original scheme.
Okay. Any further comments on conditions at all? Question 27, and it's just this point. Is it accepted that there does not need to be a reasonable prospect that the conditions have been fulfilled? I'm not saying, making no comment as to whether there would be a reasonable prospect or not, but is that generally accepted that there does not need to be a reasonable prospect that the condition can be fulfilled? I think that's the appellant's view. Mr. Mullen, do you have a view from the MOD?
Yes, the MOD's position is that that is a correct statement of the law. However, that does not mean that in appropriate cases, a decision can be taken that a suspensive condition ought not to be used where there are not reasonable prospects, basically bad planning. And this is why the MOD has referenced the Clockery and Narracombe and Section 36 decisions.
Yeah, okay. Mr. Clark, do you want to add anything to that at all.
Fingers on the microphone, so I think he wants to speak.
Okay.
Just to the second point of 27, does the evidence and science suggest that it was a reasonable prospect? Very much so. We're at advanced stages of the EWG work, and the mitigation will be beneficial for all. And we're looking at drawing that from other industries where it is standard practice. So I do believe there is a reasonable and imminent prospect.
Just to pull on the narrow account decision that's been put in, paragraph 81 of the Scottish Minister's decision, where it's discussing prospects, says the Scottish Ministers have considered the available submissions on the matter and notes there is no evidence of advancement in overcoming the significant technical and regulatory issues. The same can't be said. There's a lot of work going on to resolve the SDLMIR issues.
Okay, thank you for that.
Just to give you another reference, the Newfield decision or rather the Newfield report and associated decision letter, which have been lodged by the MOD. The reason for that, largely because of the reporter's comments on the MOD's approach, but also because at the Newfield public inquiry over 10 years ago, an engineered solution was being suggested to reducing seismic impact from turbines, and the MOD's position there was that was a research project which required very considerable further work and testing and consideration of risk by the MOD before it got to the position of an engineered solution being acceptable. So really just to note that whilst Dr. Buckingham is enthusiastic about a solution being imminent, that's far from being the MOD's position. That's the engineering solution, though, just to be very clear. That's if there was to be some discussion here around reducing impact seismologically of a turbine in order to meet a SIL.
Might I add a point to that, Mom?
Yes.
So the Newfield public inquiry was work done by ourselves, to install what was called the tune mast damper. It is one of the proposed options for this analysis work. Back in 2010, which was when we installed the device, this was pretty novel for wind turbines. I would now consider these technologies pretty much off the shelf. You can go to 4 or 5 manufacturers globally and have a retrofittable tune mast damper for a wind turbine or a chimney tower or any large tall structure. So technology has progressed significantly. We no longer offer them as a prototype device. We go to manufacturers that their sole purpose is producing devices such as this.
Also, just from what I've heard today, from the work that's been carried out, like the phase 4 report, phase 5, the refinement that's been carried out, is it more than just a research project? There seems to be quite a high level of confidence in the results. So I'm just wondering if there's a distinction there between the Newfield case, where it's a research project, and where we are now with the evidence.
If I may answer, Mom. So the original work was done back in 2005 by Professor Stiles. That was used by the MOD to safeguard the array. The Newfield public inquiry actually found that mathematics to be somewhat lacking. So following the Newfield public inquiry, the new algorithm, the current safeguarding algorithm, was produced. But at that point, seismic emissions from wind turbines were relatively new, and we only had a data set of, I think, 3 or 4 turbines. So what we did at that stage back in 2010, 2012 to 14 was intentionally produce an algorithm that was effectively an amalgamation of a couple of our data sets, because we only had so few data sets. since 2014 and this algorithm, certainly Xi have measured, we're in 10s, 20 turbines globally, and their seismic emissions, all of which have come well below the worst case turbine. So practically our data set was very small, so we were precautionary and therefore put a heavy safety factor. Now we have a much larger data set. We really understand what these machines are producing to a much better degree. Mitigation is kind of the next step, as David Bowles alluded to. This has affected the UK array earlier than some of the other arrays, but globally this is becoming an issue. So Xi are working with projects out with the UK in order to reduce seismic emission or effectively make them quiet. And the OEMs are working with us to actually further this. And there are some technologies that the TUMAS damper, which was referenced, actually prolongs the life of a wind turbine tower. So that's why it's now commonly used. It wasn't because it assists in seismic vibration. But the understanding of all of this has advanced tremendously, and the mitigation is kind of, whilst relatively new to it, we are just literally looking to other industries and pulling that technology. So for large chimney stacks, TUMAS dampers are a day-to-day event, and it's companies that produce those that the wind industry have adopted. We're going to explore those as a research work so that we can give the MOD confidence what sort of range would be achievable in terms of mitigation. But the first instance is, can you put a quiet turbine in? Some are quieter than other. And then if you need to have a very low, can we use some understood, known engineering technology from another industry and bring it across to the renewable sector? Thank you.
Dr. Burris or Mr. Mullen, do you want to comment?
Yes, ma'am. Thank you. So this is it's a very good question, actually, and I think there's many depth layers to it. So I think Dr. Buckingham answered kind of the main question, which maybe there. The first question you need to ask is, do you have a scientific method to measure ground vibrations from wind turbines that you can put into the field? It's repeatable. It's almost a standard. It's not quite there yet, but yeah, that really has moved on. Probably one of the more experts are probably the people at Xi Engineering who do the field measurements. There's not only the kind of the technical, the engineering skill, there's also the experience of knowing which peat bog is going to be a better seismic site than other peat bogs. That's just from experience. But then there is this issue of measuring many turbines, and while I agree with Dr. Buckingham, this does give us a huge amount more insight than we had. In 2014, we had 3 turbine types. There's now much more experience. I would just a little bit cautious about the fact that the ones we've measured are not necessarily the ones that are on the market and on the fields in the future. And I just an element of caution there that the technology moves on, and talking to Dr. Buckingham and his colleagues, it could be that there may be a shift in the technology where we move to different tower designs other than just metal tubes, steel tubes. It could be hybrid towers with concrete, and that would need some thought. So it's kind of a mixture. We have a kind of a method which has stopped being a research project and is now sort of a standard sorts, and then there's the technology is evolving, and whereas our experience gives us insight, it doesn't necessarily allow us to do sort of prediction and extrapolation. Thank you.
Dr. Buckingham, any response?
Well, this is the prediction versus quantification and evidence based. If you to look at the 20 shilling approach and other ones, it requires the developer to provide the evidence to the MOD in order that you don't have the concern about the prediction of new technology coming. You have physically measured it and therefore mitigated the safeguarding risk. So that's where planning conditions and so on, which are out with my expertise, but really just evidencing removes that concern.
Okay, we'll move on to the last question for this session. And this is for the Ministry of Defence. And it's really just to understand, what's your precautionary approach based on? What is there? Policy, guidance, law, practice? And do I, as the reporter and as Force Ministers, need to take a precautionary approach?
Yes, ma'am. A precautionary approach, I appreciate, exceptionally familiar with what the precautionary principle is, so I'll not go through that. But the precautionary approach is based on practice over the period of safeguarding of the array, and that approach has been followed by reporters, most recently by the reporter in the Forsyth decision. So there is established practice in terms of applying it. Now, it is worthwhile, I think, my commenting that even if the argument is one around whether the consented development planning permission has expired or not, and or whether the refusal of Forsyth has resulted in budget flowing to the consented development planning permission, that's not an example of where there is scientific uncertainty, which would be in keeping with an application of the precautionary principle. So the MOD has mentioned the precautionary approach that it takes, partly because of the significance of the array and internationally and domestically, and really just urging that caution be taken if a decision could prejudice the safeguarding of the array. But the MOD also relies on the precautionary principle in a formal way, should we be looking at applying the untested, unaccepted science yet, which is being proposed by engineering in conjunction with the SWO working group and the introduction of the SIL. In terms of the legal basis for the precautionary principle, that may be more for legal submission made along with closing submission, but the statement of agreed matters 10.1 does reference the MOD's intention to refer to the Continuity Act, which does bring in the precautionary principle to UK domestic law or Scottish domestic law.
Mr. Collar, do you want to respond?
I think, Madam, if I'm understanding Mr. Milne correctly, that final point is something that he'll develop in his closing submission. So it's maybe best left to see the detail of his point there. It's useful to get the clarification that the precautionary approach is based on practice from what Mr. Milne said, and there's no specific policy or legal principle other than the point that he just mentioned.
So it's something you'd rather respond to in a legal submission with your closing submission?
Well, in part, and sorry, yes, you're quite right. The other thing I was going to say was, I think on behalf of the appellant, all the submissions that we've made in writing leading up to this hearing, from the appeal submission itself, you've got plenty of arguments that we've made about whether the MOD are taking too cautious an approach. So I don't think there's any value in starting to repeat those.
No. We didn't cover question 16. I think we've covered it during the course of the hearing. It was about whether the planning permission for the consented scheme approves and authorises an impact as suggested by the appellant, or does the planning permission acknowledge that there's an impact which would only be acceptable mitigation in place as per condition 32? I don't know if anyone's got anyone to say on that question. I understand the MD's point is that it's zero impact. It's what the planning permission authorises, based on the fact there was no headroom or budget at that time. Does the appellant have anything you want to add in response to that?
Well, Madam, that picks up the point I made briefly. I think it was just before lunch that in looking at the planning permission and likewise the 20 shilling planning permission, there is no mention of allocation, anything like that. So the appellant's position is the seismic impact is in effect baked in the sense that it is a permission for X number of turbines in accordance with the details that are approved. I can't honestly remember, but the conditions probably refer to the approved plans, so that incorporates in all the details. So all of those parameters are baked into the permission. So I think what we're back to is, I know Mr. Milne disputed that this is a unique situation, but we're quite clear it is a unique situation because that was permission that was granted contrary to the MOD objection, and that is why there's been a lot of debate through the hearing today, which in effect is, well, what is the consequence of the issuing of that permission? And the MOD have drawn conclusions based on their position and the way they approach things. But the appellant's position is the planning permission says what the planning permission says, but more importantly, it's what it doesn't say. And it doesn't say that there is no allocation. So in the same way that a housing permission or a retail permission or whatever, you look at the terms of the permission and what is consented to the extent that it uses up capacity of whatever infrastructure, that is baked into the grant of the permission.
Mr. Milne, do you want to comment?
I think this is to repeat what we've been saying all afternoon, but the impact can't be baked in when the impact has to be mitigated expressly by condition 32.
But Madam, that's really my point, that it is granted subject to a suspensive condition requiring mitigation, but it's mitigation in terms of the development that has been consented. It doesn't say the development shall only proceed when the MOD say there is allocation, budget, headroom. I'm trying to remember the best way of putting it. Headroom, I think we've landed on as being the best. It doesn't say no development until the MOD confirm there is headroom. So in my submission that the MOD are trying to write in to the existing permission something which just quite clearly isn't there and cannot be implied into what is a normal mitigation condition. And as we've heard earlier, the same mitigation condition that was applied to 20 shilling. The MOD are trying to make that condition mean different things in different circumstances, because they're saying for 20 shilling, well, it had budget, but they're saying the same condition in the context of Little Hartfell in practice means something completely different, because according to the MOD there is no budget. But if you look at the two permissions for this purpose, They're broadly the same.
Okay. Any final comments?
No, ma'am, nothing to add.
Okay, so we've come to the end of the first hearing session. Thank you for everything that you said today. I know we did cover some ground more than once, but it's been very useful for me just to get straight in my head the things that are at issue and the crux of what the issue is on this one. We do have hearing session 2 relation to aviation lighting. Now, there's only 3 points. It might not take very long to do. I'm happy to have a short 5-10 minute break and then continue. If parties would prefer not to and reconvene tomorrow morning, that's also fine. Mr. Collar, do you have a preference?
The appellants, I think, would prefer a quick break and then finish off in the hope that it wouldn't take just too long.
I don't think it would take too long, so I'm happy to do that. Mr. Mill, what's your preference?
No, nobody is signalling to me saying that they are against that idea, and I agree that the MOD has got very little to add to this particular issue. So if Mr. Collar thinks this will not take long, then we agree.
Pressure, Mr. Collar. I don't think it will take very long. It's only 3 questions. I think we can be quite brief on it. I know David's here still webcasting, and I think he's fine until about 5 o'clock-ish, so we could take a check around about then if we haven't got through everything. But okay, let's break until 20 to 5. Is that okay? Not long enough for everyone? And we'll come back.
Thank you.
Thank you.
Send the thing up, please.
Okay, welcome back, everyone. Thanks for coming back so promptly. If we move on to hearing session 2, aviation lighting. And this is just some follow-up questions. I did ask for further submissions on this from the appellant, which they produced, and they also produced updated montages for it, which was very helpful. So it's really just a few clarificatory questions. The first one, it was just, would it be reasonable for me to assume that as it is not known whether an aviation detection lighting scheme would be available, the aviation lighting would be on all night, albeit at the lower intensity for the vast majority of the time? Is that a reasonable assumption to take?
Yes and no. Yes, in the sense that the 200 candela lights would be on for the majority of the time, from dusk till dawn. However, the only caveat I put on there is that they wouldn't be perceived at 200 candela brightness from the majority of the viewpoint locations in the surrounding area, and that's because the lights have horizontal shielding built into them that focuses the light intensity in the horizontal plane. And as soon as you get a couple of degrees above or below that horizontal plane, the intensity drops off markedly very, very quickly. So where you've got viewpoints that are lower in elevation than the hub lights, the lighting intensity is going to be much reduced from 200. And we haven't done that analysis yet for Little Hartfell, but typically in our experience of doing these things before, the candela that you perceive on the ground drops to maybe 10 or 20 candela as we look at those locations. If it would be helpful, we could certainly prepare that analysis for Little Hartfell. It normally takes a week or two to do an analysis of that nature, and if that would be helpful.
Let me just think. I'll think of that overnight. I think I've probably got enough before me from the EIA and the most recent visualizations that you sent. So I'll think, if I do need anything, I'll confirm the next day or so. So you've got enough most of that. But I'm thinking I've probably got enough information from what I have before me already. But that was helpful clarification. I'm assuming Ministry of Defence have got no comment on that question. Paul. Okay. Question 2. So a condition is proposed. Let's see if I've got it. It's in 32, I think it is. Which is different to what was looked at in the Narakan wind farm. But I'm just wondering, given the EIA assumed aviation detecting lighting scheme, which is clearly not really on the table given the current technology, is a condition appropriate in a similar way to the Narakan wind farm, given the circumstances in this case, or is there a difference between the two cases?
Yeah, so we said there's a difference between the two, but the main points I would pull out are that Narakan was found to have, by the reporter and Scottish ministers, to have unacceptable nighttime effects on a national scenic area, on the special qualities of that NSA. And the reporter concluded that implementation of an ADLS scheme was required to make that development acceptable, and recommended a suspensive condition. For that, Scottish ministers decided that such a condition was not appropriate, which is something we're taking advice on. But the contrast with Little Hartfell is that the acceptability of Little Hartfell does not depend on ADLS being operational for the site, and that our position is that the nighttime effects of the lighting are acceptable without ADLS being required. So the condition that we propose is taken from the Kilgallic extension decision, and that requires a landscape and visual mitigation scheme to be provided for the CAA lights. And the Kilgallic extension condition is good because it requires as a minimum a scheme to demonstrate mitigation for the lighting effects, either through ADLS or reduction in intensity and lighting on selected turbines only. Baked into that would be that assessment of what the actual intensity of the lights are going to be from the viewpoints around and about the area. And for us to keep this scheme under review so that ADLS could be installed in the future if and when available, if it results in mitigation. But it's very much the case that ADLS here would be a nice to have, because if we can get rid of aviation lights in the future, then let's do that. But the case is very much that the nighttime effects are acceptable in the first place, without any requirement for mitigation. And at the same time, it needs to be recognised that Cross Dykes next door is operational with aviation lighting with no ADLS required. And similarly, the consent for Little Hartfell one at 160 metres would require aviation lighting, and although the EIA discussed ADLS being imposed, there was no planning condition attached to that decision which required ADLS to be incorporated into the scheme.
Okay, so the condition that you prefer is a Kilgallic conform condition, as opposed to the one that's attached to the consent scheme.
Yes, the Kilgallic extension one is that's a good condition.
Okay, now the Ministry of Defence also suggested a condition in the statement of agreed matters. There was an MOD condition.
There's two types of lighting which are going to be required. There's MOD accredited lighting, that's one issue, and then secondly there's the CAA lights, and each type of light will need its own condition. The MOD are concerned with their MOD accredited lighting, and that would be either the 25 candela or infrared lighting to be installed. And I believe on the original consent there was a requirement for those MOD lights to be infrared only. Just so the 25 candelas are visible and aren't required. And we're perfectly happy with that position. For the MOD lights to be infrared only. If the MOD are happy with that, then that works for us.
Okay, Mr. Milne, obviously you've got your preferred condition. Is there anything you want to add on the topic of conditions?
Defer to Mr. Houghton. Do you have any? Thanks very much. The only thing we'd like to try and secure with this, or the most important thing, is that any lighting scheme is submitted to us. So we have the option to ensure that any infrared lighting is compatible with night vision devices. That's our biggest concern on this one. We would want to have the opportunity to review and approve any lighting scheme before it's implemented.
Absolutely fine with us. Oh, sorry, Mum, you're on mute.
Yes, sorry, that was very short and sweet. I have no further questions on that. That was just helpful to clarify those few points. So thank you for that. So that's the end of hearing session 2. So thank you all for your contributions to both hearing sessions. That has been very, very helpful. I suppose turning to the thought of closing submissions, legal submissions, and the timescales for that. Obviously, I don't want the closing submissions to rehearse all the evidence. It's really just pulling together what your position is on the key points in a concise format. Has anyone any thoughts about how long they would need for closing and a legal submission on the basis it would be the MOD first, followed by the appellant just a few days after that? And I'm mindful that the Easter weekend is coming up. Mr. Milne.
Would it be acceptable for the MOD to produce its closing submission and legal submission if April?
I was kind of thinking sooner than that.
What would be your preference, ma'am, just to suit obviously your availability and
I was thinking maybe 2 weeks from today, which is 2nd April, but I do appreciate there is the Easter holiday over that period, or the Easter weekend, and I don't know about your team's availability.
are people available to review this over the course of next week? Yes. Yes, 2nd April is fine.
Mr. Caller, I was thinking of an extra week for the appellant, given you have to probably respond to a legal submission too. It should be
That's fine.
9th of April.
Thank you. Yeah.
What might be useful in the meantime, just to keep things moving, is that there was discussion about 2 or 3 potential conditions that were discussed today about microsighting, measuring turbines, things like that. It might be helpful if the appellant could produce some wording for that, and I'll put an email the conditions I want covered to allow the MOD to comment on that whilst we're doing the closing submission, so it's all done in the same kind of time frame. If everyone's happy with that in principle, I will get an email out from the case officer tomorrow, just setting out what I'd like to see and giving parties time to comment on it. Would that be okay? It's just to keep things moving once you're doing your closing submissions.
I don't anticipate any problem with that, madam. I did take a quick look. Yes, I don't think it would take a huge amount of work or time.
I mean, what I do is give you, for example, till the 2nd of April to produce wording for the conditions, and give Mr. Mill out the week to comment on them. So they all kind of happen at the same kind of time frame.
Yep. That's generous, thank you.
But I'll send out an email for you, so it's very clear the wording and the issues that would need to be covered in the conditions, and that would just close that off at the same time, so I can get the report kind of written up in a good time frame.
And it occurs to me, madam, just to remind you to include the council in that part of it, given that they're conditions.
I will include the council, yes.
It just always felt a little unusual to have a hearing without the planning authority involved, but appreciate the reasons for that.
They've been copied into everything so far, including the agendas and everything else, and they've opted not to take part, but we will copy them in the conditions too, and we'll give them the same time frame to respond as Mr. Millen, just to kind of tidy it up if they choose to respond. But it's well worth reminding us of that, so thank you for that. So is there any other matters anyone wants to raise at all today? No. Well, thank you all for participating, and thank you for bearing with a long day. It's always quite hard when you're doing it online. It's quite intense, but it's been very useful from my perspective, so I really appreciate it. And we'll be in touch tomorrow just with follow-up.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you very much.